My lord, may I have my lordship's kind leave, my lord, to mention a testamentary suit. I am for the plaintiff, my learned friend is for the defendant. My lord, witness action is on. I was respectfully praying let it appear after the vacation, my lord. Any day.
Any day after vacation?
Yes.
My lord, 2 weeks after the vacation.
Yes, yes.
Yes. Will
My
the
lord,
examination
only
be
one
just
humble submission, my lord. May it appear at 3 p.m. Because this lady.
Okay, let it appear as to be mentioned after vacation.
My lord, may it appear as witness action, my lord.
Let it appear to be mentioned after vacation.
Then after a week, my lord, on reopening.
Yes.
1 week after.
My lord, may I be permitted to mention one matter, my lord? A suit of 2011, my lord. This suit has been settled by and between the parties, my lord. May it appear any days to be mentioned before vacation, my lord.
Before vacation. Okay,
Yes,
give
ma'am.
it. Intimate the other side also.
But he's here, my lord. He's for the plaintiff.
Okay, it will appear as to be mentioned.
I'm grateful.
Lordship, may I be permitted to mention one GA for inclusion in the list, Lordship? This is in regard to a development of a trust property where I was directed to serve copies upon the existing tenant. The service has been completed and the matter was supposed to appear in the list of February on 20th February.
Give the slip. It will appear after vacation.
Lordship.
We have your lordship's kind leave to mention a matter upon notice to the other side. My lord, item numbers 48 and 49,
Yes.
which is fixed at 2 p.m. today, my lord. We're in some difficulty today, some personal difficulty. I've intimated my other side and she's also okay with
48 and 40,
49.
48 is for arguments.
Yes, yes.
And 49 is
They're
also
connected
for
matters. They're connected matters, my lord. The same testamentary. My lord, we were humbly praying, my lord, kindly
other
keep
side
it.
is here.
Other side is here. And they
So
don't
let
have
it
any.
appear after vacation.
1 week after vacation, subject to your lordship's convenience.
Yes, item 48 and 49. By consent of the parties,
My lord, 2 weeks after vacation.
let this matter appear on 18/6/2025 at 3 p.m.
I'm grateful. Most grateful, my lord.
My lord, I appear onto the petition as my lord.
Yes, what is the clarification to be required? Any
My lord, the number, GA number, the year should be, my lord, 25 instead of 24. So far, other, my lord, the typographical error is concerned, my lord, your lordships granted me liberty to file an application and returnable date is 21st.
GA 275 of 2024.
24, it should be 25.
No, in your cost title, what is the
Yes,
period?
yes, 25.
Yes, record an order. Learned advocate for the petitioner is present. This matter is put up for rectification with regard to the date of the GA 275. Instead of GA 275 of 2024, it should be GA 275 of 2025 in order dated 2nd May 2025. Stop. Let necessary rectification be made. Stop. Other contents of the order dated 2nd May 2025 remain unaltered. Yes.
My lord, so far, other, my lord, correction or concern, my lord, your
So
lordship.
you come with an application.
Yes, yes, sir.
25 is the date.
But I am for some of the defendants.
My lord, I am for the applicant in this matter, my lord. And I am for the applicant may appear online. My lord, the
39. Yes. Let me
yes,
see.
This matter is
Yeah,
parted
partition.
before Justice Shogata Mojumdar matter.
In this matter, I am filing the service
Kindly
in
see the-
my
supplementary.
lord, this application is not parted perhaps. My lord, the other application, one application was made parted.
Out of the same suit.
Yes, my lord, but the this application is not parted. My lord, in that matter, my lord, there was an order for reconsideration because my lord Justice Mujumdar had passed an order of amendment and a subsequent application was pending before my lord on that issue. My lord, that application is parted. This is a new matter. My lord, it requires affidavit directions today, my lord.
As
with
you have
the-
not seen the earlier order, please go through it. I have given to my lord.
Which application it is to be
Well,
moved?
this is GA, my lord, mine is GA 39,
9 of 25.
Till date.
Today's
till
application.
GA 38.
today's application.
They have filed a new GA. My lord has.
Mr. Ratul is moving this application in this matter supplementary.
দাঁড়ান হার্ড ইন পার্ট অন্য কোর্টে করে এসেছেন আবার নিচে
No, 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 no.
My lord, that application is heard in part.
এ আবার হয় নাকি দ্যাট অ্যাপ্লিকেশন ইজ হার্ড ইন
You are appearing for respondent, learned advocate. You are for the plaintiff.
I am, my lord, I am for the applicant. I am in the plaintiff group. This is a preliminary decree was passed in 68. The plaintiff has passed away. I
You are
am the
the-
applicant, my lord.
Applicant
Yes.
intervene.
No, not intervenant, my lord. I am an applicant in the plaintiff group.
Have been done.
অ্যামেন্ডমেন্টস হয়ে গেছে
Yes.
নো নো নো
No, no amendment.
এরকম বলবেন
Is
না
representing the plaintiff.
এরকম বলবেন না
My lord, applicant in the plaintiff group. My lord will record applicant in the plaintiff group.
Being for the
অ্যাপ্লিকেন্ট
Applicant
the
under what
applicant-
capacity?
that I don't know my lord. No amendment
App-
has been done. 10
All
of
plaintiffs are dead.
expired.
All plaintiffs are.
That
all
we are placing
plaintiffs
out
defendants
report
have been
number
Okay.
expired.
What is this GA for? This GA.
My lord, this GA is for, there are several other defendants who have passed away, and some of the defendants have taken out application for transfer of their shares by way of gift deeds and other deeds without the leave of court. My lord, in this matter, a preliminary decree was passed in 1968. After the preliminary decree was passed, whenever any transfer has taken place, the transfers are subject to leave of court, and leave has been obtained from time to time. But recently, during this, I had taken out an amendment application to bring on record all the heirs. That application, I mean, order of amendment to, my lord, that was GA 33.
No, GA 39 is for what?
My lord, GA 39 is for setting aside the deed of gifts in respect of which some of the defendants have transferred their share without the leave of court. So, my lord, this requires certain directions to be passed. It has nothing to do with GA 33, where the matter was made part heard.
Learned advocate for the, your defendant number?
7.
7. Learned advocate for the
I am 8 and 9.
who sought to be impleted are present. It is submitted by learned advocate for defendant number 7 that this, some of the applications are hard in part,
All.
that all the applications 7 except GA 39 of 2025 are hard in part before another bench, another learned bench of this on court.
That's
Stop.
Sugata Mujumdar. You can lordship can say that's Sugata Mujumdar.
Learned advocate also submits the order passed by Honorable Justice Sugata Mujumdar on 18th January 2024, treating the applications as part heard. Stop. In the facts and circumstances, this application GA 39 of 2025 is released from this bench. Stop. It may be placed before the bench who is taking up part heard applications of this instant suit.
Much obliged, my lord.
But it will be placed with after holiday.
Whatever it is, you
Well,
place it.
Much obliged, my lord.
Yeah.
Yes, pass over. You are for?
Petitioners, applicants.
Yes.
In terms of the earlier order, service has been effected on the
What is this application for?
application for appointment of the legal heirs of the plaintiffs as a joint trustees. Suit was decreed 1972 as per the by virtue of settlement, and the applicants are the legal heirs of plaintiff number 3. Plaintiff number 3, applicants before your lordships are the legal heirs of plaintiff number 3. And plaintiff number 1 and 2 all are died, and even defendant number are also died. Service effected upon the legal heirs of the defendants. As per terms of the settlement, defendants and plaintiffs both are entitled to act as the trustee and to perform the other activities of the trusted properties. Now the legal heirs of the defendant of the plaintiff number 3 seeking appropriate order so that they could came and maintain along with the legal heirs of the defendants to the trusted property, maintain and other management.
No, who are the applicants in this case?
Applicants are the legal heirs of the plaintiff number 3. Plaintiff number 1 died.
Applicants are the legal heirs of plaintiff number 3.
3. Page paragraph 8. Kindly have a look at paragraph 8.
Yes, let me see the affidavit of service. Notice of motion. Affidavit of service.
Learned advocate from Canadian company appeared on behalf of the
So in terms of the leave granted, you have caused service upon the surviving descendants of the deceased defendants.
my lord. And they appeared
No, in this matter, GA, in this GA.
in this jail.
Okay, I'm keeping it on Wednesday. Serve them, issue them notice. If they don't appear, necessary orders will be passed. Learned advocate for the applicants, legal heirs of the plaintiff number 3 is present. None appears on behalf of defendant number. These are the heirs of defendant number 3.
Even number 3.
None appears on behalf of the heirs of defendant number 3, although they have appeared on February 11, 2020, although they have appeared on the last occasion. Thus, this matter stands adjourned till 21.
My lord, different number, the learned advocate wrote a letter on behalf of the different legal heirs on behalf of the different number 2, that is Sholendra Das. And no one appeared on behalf of the different number 1, Indra Kumar Das.
So you have served upon the legal heirs of
All legal
defendant
heirs, 1 and 2.
1 and 2.
1 and 2, all legal heirs are.
So who is represented in this matter?
Different number 2, only different number legal heirs from different number 2 on.
Is already represented.
They appeared on.
Let this matter appear on 21/5/2025. Learned advocate for the applicant shall serve one more notice upon learned advocate appearing for legal heirs of defendant number 2 and 2.
And even my lord, if you my lord wish, I can also serve it.
2 and 1,
1.
intimating the next date fixed. So it will be taken up on 21st.
Evidence has be kept on record.
Let affidavit of service file be kept with the record.
May I take back that later?
Yes.
Item number 5,
My lord, this is my,
International Institute of Bengal Basin.
this is my application, my lord. It is an application for restoration of an order, my lord, passed on 7th of February 2023 by the Honorable Justice Sugata Majumdar in connection with a suit which had been dismissed for default. But I frankly admit your lordship, there has been a delay, my lord,
No,
in
no.
taking out this
The
application.
suit was dismissed
The suit was dismissed, my lord.
on 7th February
7th
2020.
of February 2023
Yes.
by Honorable Justice Sugata Majumdar.
Yes. So
But
when
my lord, my lord, there is a delay, I frankly admit, my lord.
when
So I
when,
had
when did
taken
you
out
file this
another-
application?
My lord, this application had been filed, my lord, on 2024, my lord, probably.
15th January.
15 January 2025. There had been a delay, so I had taken out a separate application, my lord, under section 5. I humbly pray before your lordship.
What
kindly
is that
restore this
application? Let me see.
No, well, it's the same prayer.
Oh.
The,
Oh, yes.
that prayer is there. Sir, may I file an affidavit to this? 709 days delay in filing an application for
There are
restoration.
causes, my lord. I shall
May I
satisfy your
We
lordship.
exchange affidavits and come back, lordship will decide.
Yes, record an order. Learned advocate for the petitioner plaintiff is present. GA 3 of 2025 is taken up for consideration. Learned advocate for the defendant respondent prays for leave to file affidavit in opposition. Such leave is granted. Let affidavit in opposition be filed by 13/6/2025. Reply, if any, be filed by 18/6/2025. Let this matter appear on 19/6/2025.
May I file my affidavit of service, my lord?
Yes, let the affidavit of service filed be kept with the record.
Grateful, my lord.
Please, your lordship.
My lord, item number 6, my lord, I appear for the plaintiffs, my lord. I'm only praying for a short passover, my lord. It's a very short
You are
passover.
appearing
my lord.
for
My lord, for the plaintiffs.
all the plaintiffs.
My lord, save and accept plaintiff number 10.
My lord, this is my application. I can
Sir.
place the application.
You are praying
yes,
for a short
sure.
passover. Okay,
Yes,
short
my lord.
passover. It will be taken up in the second call.
Item number 7, Bhuturia Brothers Private Limited.
Madam, this is my application for Madam, introducing one document for the suit for the in the suit where issues have not been framed. But in this application affidavits have been exchanged. There's only one document which I seek to introduce at this stage. It's a valuous report.
Let me see the application. On 1st May, there was a direction there was a liberty granted to file affidavit in opposition.
Yes, and that has been filed. My reply is also on record. I've served it as well.
Other side is here.
Yeah, I don't find them. It's the union, Madam, they had appeared on the last occasion.
Let me see this.
But this is the document one which I seek to introduce. But here it is a valuous report. But calculating the mean profits or the money that I could have realized out of the property if it had been utilized by me for a brief period. The suit is for damages against the government. They had illegally taken possession of my premises and which was eventually given back to me in 2013.
Yes, who is appearing? You are for Union of
Yes,
India.
my
Yes.
lord. I'm led by Mr. U.S. Bhattacharya, my lord. He's on his legs before court number 5, my lord. Can he, my lord, short pass over, my lord?
This application may be not allowed. No harm would be.
My lord, we have filed our objection. They've already filed their reply, my lord.
Yes. Okay, I shall take it up day after tomorrow.
Yes, my lord.
Yes. Learned advocate for the petitioner plaintiff and learned advocate for the defendant opposite party are present. GA 4 of 2024 is taken up for consideration. Time is prayed for on behalf of the opposite party defendant. In the interest of justice, the matter stands adjourned till 21/5/2025. I'm ready on 21st.
21st. Grateful.
একজন মোশনটা ডেকে নিন তারপরে।
Actual motion item number 8 AKR consultants private.
Is your lordship, my lord, I appear for the petitioner. I had
Sure, and for
concluded
the
my
defendant.
arguments. On 30th April, the respondent had started his submission. My lord, this is
I
a
apologize beforehand because today I'm compelled to seek for an adjournment because I'm being laid by Mr. Bag in the matter. But due to some personal difficulty, he's not here. Kashyap, I understand that I'm taking time and my learned friends, senior friends are going to object to that. But today it is really
Let it be taken up tomorrow.
Kashyap, tomorrow or day after tomorrow. Day after tomorrow would be.
Yes, record an order. Learned counsel for the plaintiff is present on behalf of the defendant opposite party. Time is sought for. You are for the defendant.
Defendant number 5.
Defendant number 5 opposite party. Time is sought for. In the interest of justice, the prayer is allowed. Let this matter appear on 21/5/2025.
Yeah. My lord, would your lordship be pleased to fix a time? On the last occasion, time was fixed as this was a part of continuing matter. My lord, your lordship sees the order of 30th April. Today was fixed for hearing.
21/5/2025. আচ্ছা 21 তারিখে কি কোনো ফিক্সড আছে? তিনটের সময় কি দুটোর সময়?
21 তারিখে judge সাহেব issue.
আচ্ছা আর ইয়েতে 2 PM এ কিছু নেই।
सुबह को ही कौन हो जाएगा? Let it
2
be
PM?
its position in the
Okay, at 2 PM.
Please, my lord. Deeply obliged.
I'm grateful.
As a last chance, my lord, kindly.
Anyway, it will be taken up definitely.
Grateful.
Item number 9 surplus Ahmed and another
Yes, pass over.
10 Haji Muhammad Sirajuddin.
Yes, pass over.
11 Hamida Zakir and others.
Did I appear for the petition?
Here for this respondent number 6, 7, and 8.
Well, I'm for 1 and 4. Respondent numbers 1 and 4.
Well, look, this is an application for passing of a final decree in terms of a preliminary decree which had been passed by consent of the parties
Yes.
way back, my lord, in the year 2017.
Yes.
This was a partition suit.
11.
In the partition suit, my lord, an application was taken out for the usual order. Now, during the pendency of the interlocutory application,
Applications.
what about the GA number 4? No, 8.
No, today GA 8 of 2025 is happening.
8.
8.
No. What did I just tell your lordship, if necessary, if the papers are not here, my lord? Oh, I thought. So, my lord, when the partition suit was filed, an interlocutory application was taken out. And in the interlocutory application, the parties came to a settlement. Terms of settlement were filed. I shall have to place the terms of settlement in detail before your lordship, on the basis whereof a consent preliminary decree was passed. Now, since then, my lord, some of the parties are trying to get a final decree passed in accordance with the consent preliminary decree. I'm not making any allegations against anybody.
Anyway,
But
the
because-
commissioner of partition was appointed.
My lord, what happened was, later on, commissioner was appointed. Now, there are 4 properties involved. The parties were in possession of different portions of the said property. 2 parties who were actually collecting the prime rents, issues, and profits from 2 of the properties were delaying, my lord, in handing over the allocated portions to each of the individual parties on some flimsy ground or the other. We took out many applications. Applications, my lord, were heard, and there was a direction upon the party concerned, my lord, to do the needful. A commissioner was appointed. Commissioner gave a report where he said that 2 of the parties were playing truant with the court. Finally, my lord, barring those 2, the other plaintiffs and defendants have come to an agreement. They have signed the terms of settlement, and they want a final decree to be filed on the basis of the terms of settlement in respect of the properties which have been allocated to them, and they will have no right, title, and interest in respect of the properties in which are in the possession of the respondents who are contesting the proceedings. So, my lord, if they do not come to terms even for that, well and good. Otherwise, my lord, we shall walk away with whatever is available to us. That is the scope and purport of the application. Now, my lord, I
So
tell you, Lord,
whatever they have, whatever position they are now,
it has to be given to the respective parties, because the consent preliminary decree talks about who will get which property, and that is the problem. Unless the parties are placed in respective possession of their respective portions.
preliminary decree, we cannot go beyond that.
No.
That share is declared, we can, unless it is set as a
We are not asking for your lordship to go beyond the preliminary decree. In terms of the preliminary decree, it is possible to ascertain who will get what. So we just want to walk out of the scene with whatever we have, as and when they settle. It will take a little time because I'll have to place the decree in a little bit of detail. My lord, I am being very candid before my lord. But before the vacations, if my lord wants to take it up, I am ready and willing to do it. But this will take a little time. Otherwise, if my lord wants to place it after the vacation, it is entirely up to
If
my
all of you can conclude it before vacation, well and good.
I believe all the parties need to submit their respective portions. I mean,
I can complete my share. I do not know what the others will say. It is entirely up to my lord.
No, if you can complete your arguments, definitely well and good. If you cannot complete, then I have to give it after vacation.
We can. I do not know about the others.
Yes, but can you complete before
well,
vacation?
I don't think so.
Okay.
Well, then keep it 1 week after the vacation, but if it is possible, my lord, kindly keep it at a fixed time.
That will be better.
16 বা 17 তারিখে দেখুন তো কোনো ফিক্সড টাইম আছে কিনা 17 বা 16 তে যে কোনো একদিন 16 17 18 দুটো কি তিনটের সময় কোনো ফিক্সড টাইম আছে ওগুলোতে ফিক্সড টাইম নেই Yes, record and order. Learned counsels for the parties are present. Heard. learned counsels on the application GA 8 of 2025. As the hearing cannot be completed before vacation, the matter stands adjourned to 16/6/2025, 1 week after vacation.
Yes, 16.
At 2 p.m.
Very well. Grateful, very grateful to my lord.
Yes, call the Passover matters. Second call. Yes, not today.
I appear for the defendants.
My lord, I appear on behalf of one of the plaintiff. It is my application, plaintiff number 10. Your lordship has been pleased to, my lord, notice that my learned friend who had sought adjournment or the Passover was.
This is your application, GA11.
Yes, my lord. I am for the plaintiff number 10. My lord, all the plaintiffs are the partners of a partnership firm. My lord, apart from plaintiff number 10, my lord, other plaintiffs are appearing in one group. The defendant is there, and my lord, the plaintiff number 10 is appearing separately. Your lordship, my lord, I am troubling your lordship for the purpose of variation of the order passed by your lordship on the 2nd of May 2025. That will appear at page 245 of this petition, my lord. Volume 2, if your lordship kindly comes. 245.
Volume 2 ta din.
Second of May. Your lordship has got, my lord?
Yes.
My lord, may I just read out? Learned advocate representing the plaintiff and the learned advocate representing the defendant are present. My lord, here I pause for a moment. Learned advocate representing all the plaintiffs were not present. My lord, my main case is that your lordship has been led to pass this order on facts which were not proper. There has been misrepresentation of facts. So, my lord, the first line itself, I'm joining issue. The learned advocate representing the plaintiff and the learned advocate representing the defendant are present. All the plaintiffs were not represented, number one. Mr. Seal, former advocate of the plaintiff, is also present. This is very important, my lord. Mr. Seal was, my lord, entrusted to look after the matter at one point of time for all the plaintiffs. Thereafter, my lord, Mr. Seal, my lord, was specifically instructed by my client, the letters of which I'll show before your lordship, to say that he is withdrawing his power, taking his responsibility, capacity, and appointing someone else, inasmuch as my client expressed his willingness not to withdraw the suit. We had come to know that the other plaintiffs were, my lord, wanting to withdraw the suit, inasmuch as there must have been, inasmuch as there must have been some arrangement for settlement,
Which he is aware of and which he has got the
my lord,
consideration
this
of.
I don't appreciate. My lord, this
I'll
I don't
indicate.
appreciate. My lord, may I have my pleasure of submitting before my lord? My learned friend will get that opportunity.
Yes, yes.
Both together we can't do. This is not done. My lord, my cases, specific cases that my client had specifically instructed Mr. Seal that I am not wanting to withdraw and that I am appearing through someone else. My lord, this is very important. Then, my lord, it is submitted by the learned advocate representing the plaintiffs. Again, this is wrong, not all the plaintiffs, and the defendants, that the parties have settled their disputes and the suit may be disposed of. The terms of settlement is also filed in court.
So, Mr. Sheel was representing all the plaintiffs.
At one point of time, before I had withdrawn his, my lord, Wakalatnama, I had specifically said that I am not wanting to get the suit withdrawn and that I am appointing someone else. Then, my lord, paragraph 4.
Upon hearing learned advocates for the parties and considering the terms of settlements, this court is of the view that the prayer for withdrawal of the suit should be allowed, as usual, my lord, as your lordship's passes. But advocates for the parties, again, my lord, I join issue here, all the parties were not represented. Thus, the prayer for the plaintiff to withdraw the suit stands allowed. The suit be treated dismissed as withdrawn. However, as defendants have deposited a sum of rupees 21 lakhs with the receiver, and the same is invested in a term deposit with the State Bank of India, let a report be submitted as to the amount lying to the credit of the suit in the State Bank of India by 13th of May, such and such. And the matter had appeared on the 13th of May when your lordship was pleased to keep the matter for the day's hearing, inasmuch as we brought it to the notice of my lord that the application has been filed. And my lord, one more point I would like to indicate before your lordship. Your lordship will kindly come to the first page under the heading appearance. Page 245, my lord. Your lordship will kindly see.
Page 245.
Yes, my lord. That just the earlier page. My lord, under the heading appearance, Mr. Topon Shil, advocate, erstwhile advocate on record of the plaintiffs. Erstwhile advocate on record of the plaintiffs. Now, my lord, may I take your lordship to page 203. That is also in the second volume. Page 203. My lord, your lordship will be pleased to see the date. 20th of March 2025. They've received it, 20th of March 2025, and this order is of May. My lord, my client is addressing to Chatterjee Seal and Company. My lord, I will not trouble your lordship with the entire, my lord, order. Anyway, my lord, it's not a very long letter. First of all, thank you for informing me over phone about the letter dated 13th March 2025. I'll read that letter, my lord. Sent to your office by one Shom Shankar Mukhopadhyay, claiming himself as a partner of Messrs. Ashutosh Roy, Prafulla Roy, Kumar Roy. In this context, I would like to inform you by this letter that I am nowhere authorized the said Shom Shankar Mukhopadhyay to issue the letter dated 13th March 2025 for withdrawing the above mentioned suit being such and such. This is the suit pending before the Honorable High Court at Calcutta. Not only this is to inform you that as per my knowledge and records, the said Shom Shankar Mukhopadhyay is no more partner of Messrs. Ashutosh Roy, Prafulla Kumar Roy, partnership firm. He has also assigned all his right as a partner to Mrs. Shonali Roy, the other partner of Messrs. Ashutosh Roy, Prafulla Kumar Roy, partnership firm. Therefore, as a lawful existing partner of Messrs. Ashutosh Roy, Prafulla Kumar Roy, partnership firm, my humble request before you not to take any action for withdrawing the above mentioned suit on the basis of the letter dated 13th of March 2025. Furthermore, kindly issue no objection wakalatnama in my favor in the above mentioned suit. So, my lord, this is in response to a letter that was given to me, the letter dated 13th of March 2025, which was written by, my lord, one of the plaintiffs who is claiming to be the constituted attorney, that is the plaintiff number 9. My lord, the letter of the 13th of March 2025 will appear at page 185. This was in response to that.
Yes. What is the other letter?
Yes, my lord. Page 185, your lordship will kindly come. The other letter that I had written to Chatterjee Seal was in response to this letter that I received, 13th of March.
Yes.
This letter is being written by my lord Shom Shankar Mukhopadhyay, the plaintiff number 9, who is instrumental in getting the suit withdrawn. Please note that the plaintiffs do not wish to proceed with the above mentioned suit.
No, this Ashutosh Roy MS is a proprietorship firm.
In partnership.
Partnership
These are all
firm.
partners. These are all partners.
Ashutosh
Excepting
Roy-
him, he's not a partner.
M.S. Ashutosh Roy and Prafulla Kumar Roy, yes.
Yes, my learned friend
The Somshankar Mukhopadhyay.
Som Shankar Mukhopadhyay is one of the plaintiff number 9. He's instrumental in getting the suit withdrawn. My lord, my learned friend I thought was for the defendant. He is espousing the cause of the plaintiff since the last hearing. So your lordship can very well understand what is the relationship between the rest of the plaintiffs after I finish.
It is at my instance that his client got convicted. He was remanded to prison, and my lord, he never participated in the settlement. I will show.
Yes, let my learned friend, my lord, your lordship will kindly
So this is 13th March letter was from your side to Chatterjee and Shill.
No.
No. That is, you see, plaintiff. This firm, this is the letter written by the firm.
This is written by the firm to Chatterjee Seal, the erstwhile advocate
The
and
other
record.
letter you was by yourself, personal capacity.
Yes,
That is page
203.
203 is in your personal capacity.
Yes, after I received this letter of 13th March from Chatterjee Seal, I replied to Chatterjee Seal, said, listen, I am not wanting to withdraw. Rather, you give me a no objection. I would like to get myself represented to someone else. So, my lord, 13th March, they are saying, please note that the plaintiffs do not, it should be, wish to proceed with the above mentioned suit. In such circumstances, you are instructed to take necessary steps for withdrawal of the suit against the defendants. I'm not wanting to withdraw this. That is exactly what I wanted to say by the letter dated 20th March 2025, appearing at page 203.
185 letter is 13th March 2025.
Yes.
Okay, this is by the firm. 13th March
This is
2025.
by the firm.
By the firm. Okay.
By the firm.
And 23
My lord,
2000.
let my learned friend then finish. My lord, your lord,
Yes,
kindly
28th March 2025 is in your personal.
this practice of getting up and this, my
No,
lord, we have never heard.
Because I'll just indicate.
Anyway, I am just ascertaining the facts of the case.
Yes.
Okay, I'm not going into any.
Because my learned senior friend said it's not the firm. It is the firm. How can he deny that?
Either it has to be
the
a
practice of writing notes.
No. Either it has to be a firm or a proprietorship concern. Okay.
Yes. May have it. Might have gone away.
Either firm or partnership. So I'm just ascertaining the facts.
Finish. We had the practice of writing notes when the other side makes submission so that we can retaliate. Just by jumping up every second, this I suppose was not the practice.
Okay,
Now,
20th March
this is the practice. Yes, my lord.
20th March is in your personal capacity.
My personal capacity, my
So
lord.
what letterhead you are using? M.S. Ashutosh Roy, Prafulla Kumar Roy.
Yes.
That is the
I am a partner.
Not a partner.
I am a partner. Your lordship will kindly see the plaintiff number 10. I am a partner of the firm. I will show to it
Till today.
Yes, till today. The plaintiff says I am plaintiff number 10.
Okay. Now this is, I have considered, that is page 203 and page 185.
Yes, 185 was the first letter. In reply to that, page 203. I am specifically saying that I am not wanting to withdraw the suit.
That means you have dissociated yourself from 13th March letter.
Exactly, my lord. Exactly. And it is not only that Chatterjee Seal was intimated, but the rest of the partners have all been intimated. Your lordship will kindly see page 206.
204, copy 2.
Yes, from 204 it starts. Page 206, your lordship will kindly come. Messrs. Chatterjee Seal is now, my lord, writing this letter to the partnership firm. My lord, I will not trouble your lordship with the entire, my lordship will kindly come to the second paragraph. Now on 24th March 2025, we received a letter dated 20th March 2025, that is my letter, signed by Sujoy Mukherjee, claiming to be a partner of your firm, alleging that we have informed him over telephone about the aforesaid letter dated 13th March 2024, and also informed that as per record...
That is page 206.
206, yes, my lord.
Yes.
The second paragraph, my lord, I am reading. that as per records, the said Somshankar Mukhopadhyay is no more partner of Mrs. Ashutosh Roy, Prafulla Kumar Roy partnership firm. Then, please note that we did not inform anybody over telephone, and we have no knowledge that the said Somshankar Mukhopadhyay has already assigned all his right as a partner to Mrs. Sonali Roy and another partner of your firm. The said Sujoy Mukherjee also asked us to issue no objection wakalatnama in his favor for above mentioned suit. So this is way back on 25th of March 2025. And my lord, my lord's order is of 2nd May 2025, when nothing has been brought before my lord, that plaintiff number 10 is not wanting to withdraw. Plaintiff number 10 wants the no objection to be given. Plaintiff number 10 wants a separate wakalatnama to be filed in favor of some other learned advocate. Nothing has been brought to the notice. What has been represented before my lord is all the plaintiffs and defendants are willing to withdraw the suit. So this is the representation that has led my lord to pass the order dated 2nd of May 2025. Then, my lord, I'll show to your lordship, my lord, page 208. Then, my lord, your lordship will kindly come to page 208. On the 25th of April 2025, my lord, at 7:30, my lord, the present advocate on record, Ms. Falguni Jana, is intimating Chatterjee seal. Please note that I, the undersigned, have filed wakalatnama on behalf of my above named client in the subject proceeding. Henceforth, he will be represented by me in the subject suit, and all the steps for and on his behalf will be taken by me, as instructed and in accordance with law. As such, you are hereby requested not to take any step in the subject suit for and on behalf of my above named client, that is plaintiff number 10, anymore. You are also requested not to take any action, but to proceed with the same. Specific. And on that particular day, my lord, the present advocate on record has filed a wakalatnama pursuant to leave sought for from this honorable court on 25th April.
This is plaintiff number 10, it is mentioned.
Yes.
Is not inclined to withdraw the action, but to proceed with the same.
Yes, yes. And that you are hereby requested not to take any step in the subject suit for and on behalf of my above named client, that is the plaintiff number 10, anymore. 25th April 2025. And my lord, the last line, you are also requested not to take any action, any step for withdrawal of the suit, inasmuch as my above named client, that is plaintiff number 10, is not inclined to withdraw the action, but to proceed with the same. Specific. Then, my lord, your lordship will be pleased to come to the rest of the pages. Pages 209 to 240 are intimation to all the rest of the plaintiffs, of which I'll trouble your lordship only, my lord, with 210. Most of them, my lord, out of 11, I'll be precise, my lord, out of 12 plaintiffs, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 have received. And the 2 have come out and what address?
Addressee cannot be located.
Addressee cannot be located.
The plaintiffs, no, Bharadwaj, this present advocate, 200
yes,
advocate is the advocate of the?
Defendant, plaintiff number 10.
Plaintiff number 10?
Yes.
So he was engaged when?
25th of
when?
25th of April 2025, page 208.
25th of April
2025.
No, this is okay, right.
That day, my lord, she filed the wakalatnama pursuant to leave granted by this honorable court. And that is the day that she intimated Chatterjee Seal that you are no longer to represent.
No, page 25, April 2025 is by Falguni Jana to Bharadwaj, Law Chamber.
No.
Page 208.
208 is Falguni Jana of Bharadwaj Law Chamber.
Oh, Bharadwaj, okay.
To Chatterjee Seal, my lord,
Right,
at
right,
the
right.
top, my lord.
Right.
MS Falguni Jana is from Bharadwaj Law Chamber.
Okay, so for plaintiff number 10 is concerned.
Yes, plaintiff number 10, specific. And that I don't want to withdraw. Then, my lord.
And intimated all the...
Yes, page 209 onwards, your lordship will kindly see. 209. I should be very candid with your lordship. 209, my lord, there are 12 plaintiffs, out of which 1, 2, 3, 4, 5, 6, 7, 9, 10 have received. And 2, my lord, they are saying addressee not known.
Cannot be located.
Oh, addressee cannot be located. We have sent at their address, which is there in the plaint, but it has come out saying that addressee cannot be located. Now, my lord, I will trouble your lordship only one line of this letter. That is the last line at page 210. You are also requested not to take any step for withdrawal of the suit inasmuch as my above named client, that is the plaintiff number 10, is not inclined to withdraw the action but to proceed with the same. So, my lord, specific, this is again on the 28th of April 2025. So, my lord, your lordship has seen that at the time of passing of the order on 2nd of May 2025, this fact was brought not only to the notice of the rest of the plaintiffs, but also to the notice of the erstwhile advocate on record, Chatterjee Seal. But such fact that one particular plaintiff has given specific instruction not to withdraw and that he is appearing through some other advocate has not been brought before my lord. Your lordship knows in a partnership action, my lord, it has to be to common advantage of all the partners. My lord, that's common, and it has to be the prime purpose has to be for the benefit of the partnership firm. Now, my lord, I'll demonstrate to your lordship as to why all of a sudden, since 2013 till up to 2018, the plaintiffs and the defendants had been fighting tooth and nail. I'll say all this, there are orders. All of a sudden, what happens? That now they have become so friendly, they want to withdraw the suit. And what is the suit for? It is with regard to a very valuable property in the central part of the city, 1,700 square feet. Defendant is claiming to be in legal possession when the plaintiff's case is that they were only given as a caretaker. My lord, the prayers in the plaint, your lordship will kindly see, page 42. It is just not, my lord, a few amount of rupees that is involved. What is going on between the plaintiff, rest of the plaintiffs and the defendant is the most important thing. Page 42, your lordship kindly see.
Yes.
The gravity of the
eviction.
Suit. Yes. Page 42.
Yes. Prayer of the plaintiff.
Yes. Decree for eviction under defendant numbers 1, 2, and 3 from go down numbers such and such. This go down, my lord, is of 1,700 square feet on 10 Portuguese Church Street. Very valuable property. 1,700 square feet. And my lord, the main defense of the defendants, I'll just read out one paragraph from the written statement, will appear at page 61.
Yes.
Page 61, your lordship has got, my lord. This is a part of the written statement. I'll not trouble entirely. My lord, subparagraph A, if your lordship kindly comes. The plaintiff would surrender tenancy to.
Page 61 of this application.
Yes, my lord. Page 61 of this application.
No, the plaintiff would surrender.
Yes, this is the crux of the defendant's case in the suit. The plaintiff would surrender tenancy to Waqf estate in order to facilitate the grant of tenancy directly by the Waqf estate in favor of the defendants. So the defendants are wanting that this particular property would be surrendered by the plaintiffs and the defendants will be the direct tenants of the Waqf estate. So the plaintiffs will go out of the picture. Plaintiffs are claiming to have the tenancy right and that the defendant was given as a caretaker. Now this is the stand of the defendant in crux. So for
Relief
which
sought for is eviction of the defendant.
yes.
That is the relief sought for.
That was the relief sought for. Eviction of the defendant from a premises of 1700 square feet in a very prime commercial area in Calcutta. So that is, my lord, the gravity of the suit. Now, my lord, page 94. I'll just take your lordship only to the important portions. Page 94. Plenty of orders have been passed. The defendant went up in appeal. All this was done. All on a sudden, my lord, there's a change of direction. Your lordship will kindly come to page 94, last paragraph. This is a part of the order of my lord, Mr. Justice I.P. Mukherjee. Last, my lord, last paragraph at page 94. Your lordship has got it, my lord?
Yes.
In spite of directions, no affidavit in opposition was filed by the defendants. No documents are on record to show their entitlement to such possession. There is no dispute that the defendants had entered into the two go-downs as caretakers, but now they claim rights adverse to that of the plaintiffs. So that is how the defendants are claiming their right, to which the plaintiffs, all the plaintiffs at one point of time, was fighting tooth and nail. Therefore, on the above case, the plaintiff's right of possession is prima facie established. So this is a part of the order that was passed in the course of the hearing. Then, my lord, your lordship will kindly come to pages 99 and 101. Page 99 is also a part of the order passed by Justice I.P. Mukherjee on 14th of July 2015. Only one line, my lord. Page 99, your lordship will kindly come. To paragraph 3. Considering all these facts, I am not inclined to vacate or modify the order dated 27 January 2014, which is an interim order. However, since the suit has progressed and is now ready for trial, this order should not be used to dispossess the defendants in case of any default till such and such. What I want to impress upon my lord is that way back on 14th of July 2015, the suit was already ready for trial. I put a question to myself, what was the constituted attorney doing all this while? He has given in the terms of settlement that it is because of the suit is onerous in nature, as a result of which the parties are entering into the terms of settlement. I'll come to that. Whether the terms of settlement were at all signed by all of them is also a question of fact. They rely on a meeting that was held in 2024. We were not a party to that meeting. We do not have the copy of the minutes. Everything is vague. Everything is vague. Then, my lord, 101, your lordship will kindly come. 16th August 2017, Justice Haidullah Munshi, as his lordship then was. It is submitted by the counsel appearing for the parties that the suit is otherwise ready for hearing. Let the suit be included in the list of August such and such. So, again, on 16th August 2017, it was observed by this Honorable Court that the suit was ready for hearing. Then, my lord, your lordship will be pleased to come to page 102. This is the nature of the dispute that is involved. Page 102 is the issues that have been framed. So many issues, 23 issues. Defendants were all throughout there. Issues got reframed. Page 112. Way back on 15th of September 2017.
Yes.
issues got reframed, so many issues. What I'm trying to impress upon your lordship is the dispute that is involved. It cannot just be, my lord, put to rest by some of the plaintiffs. Then
All of the plaintiffs except you.
yes, yes, that my lord has come to know by this time. Then, my lord, page 120, all observation of this honorable court in the presence of both the parties. 5th of July 2018, page 120.
So time to time, different orders were passed.
Yes, yes. From time to time, different orders. I'm just wanting to impress upon your lordship the gravity that is involved in the suit. My lord, your lordship will kindly see the last line. I'll not trouble your lordship with the entire orders, only the important lines. He submits, however, that since it is a contested matter, the originals of the documents enumerated in the two notices are produced. Contested matter. Matter is heavily contested. That is the observation of this honorable court. Then, my lord, page 122 and 123.
First time that
Examination.
that a matter at trial is also settled.
Again,
See,
my
unheard of.
again, my learned friend, my lord, in the midst, I do not understand. Examination in chief of the plaintiff's witness, my lord, commenced. 123 and 122, my lord, they are evidence of that. 122 and 123. (122), my lord, the last line, matter is required to be expedited since examination in chief has already commenced and was due to continue today. So, my lord, 122 and 123, examination in chief of the plaintiff's witness, my lord. So, examination in chief of the witness means of the constituted attorney, plaintiff number 9, started. Then, my lord, page 144. These defendants, my lord, those who are so keen on now getting the suit settled for reasons best known to all of us, my lord, had taken a lot of pains going up before the Honorable Appeal Court, when their, my lord, amendment was disallowed by the Honorable Trial Court, they had gone up till up to the Appeal Court. So then they were till up to 2019, they were fighting tooth and nail. That is what I want to impress upon your lordship.
So examination in
chief, yes, it has
the
started.
evidence of the plaintiff's witness commenced.
Yes, that's recorded in pages, the orders appearing at pages 122 and 123. Yes, Madam. Now, my lord, your lordship will recall that the terms of settlement was filed pursuant to which your lordship was made to pass the order dated 2nd of May 2025. My lord, there, my lord, if your lordship kindly has a look at the terms of settlement. I've got a certified copy.
Yes, which order? That is
no, the terms of settlement, one word, which has been referred to in your lordship's order dated 2nd May 2025.
Yes.
Your lordship has got a copy of the terms.
Here in this, it is annexed.
No, it must be filed in court.
No, original is definitely there. Have you annexed any copy?
No.
Is there, then only the original terms will be there. Does the recalling application won't have the terms?
It is.
Yes. Anyway, this is done by the constituted attorney. This is an admitted position.
When?
Date of entering into settlement.
When, after, my lord, I had intimated that I want to,
Constituted attorney.
I do not wish, after, yes, I informed everyone that I do not wish to withdraw the suit.
This is the date is
5th of May. No, 30th of April.
30th.
I had intimated prior to this. That I do not want to withdraw the suit and that I am going to appear through an independent lawyer. Honoris কথাটা কোথায় আছে? Now, my lord, paragraph 6, I will not trouble you in, your lordship entirely. I'll just refer to 2 paragraphs. Paragraph 6.
Yes.
The reason, my lord. No progress in the suit has taken place till date, and cost of litigation and other expenses have become onerous on the parties, and it would be in the interest of the partnership firm that the suit be withdrawn. My lord, here I have demonstrated before my lord as to what was the progress made in the suit. And way back in 2017 and 18, my lord, this honorable court repeatedly had observed that the suit is ready. I put a question to myself. What step did the constituted attorney take thereafter to proceed with the suit?
Anyway, that cannot be decided in
To say as to whether the terms under which they are wanting to withdraw the suit, pursuant to which the suit has been withdrawn, is correct or not. That your
civil suits can be withdrawn, provided we have to see that the terms of settlement are not illegal. That is the thing.
Whether the terms of settlement also, my lord, project
Not against public policy or not.
2 or 3 things, my lord, with deepest of respect. First of all, my lord, I'll place a particular order, Order 23, Rule 3, my lord. If there are more than 1 plaintiffs.
So this is no progress, is the interpretation of these parties.
If your lordship says that, my lord, I would, my lord, submit that this progress was not made with an intention, because I have shown orders passed
Yes,
by
that
my
may-
lord.
that's a different issue.
So, my lord, whether no progress in the suit has taken place can be said or not is a question that your lordship has to consider.
Anyway, your client was not dissatisfied with the progress of the suit. It may be.
My client was, depending on him, he's claiming to be the constituted attorney till the time I said that no, I do not want to withdraw the suit, because then I found
Later revoking the power,
no,
power.
I had not formally
Intimation given that you are engaging another advocate.
Yes.
Okay.
And that
you are
I'm not
interested-
wanting to withdraw.
Regarding the suit, your intention to proceed with the suit, your intention to give a change to the advocate.
Yes.
But regarding the
No, I have
devolution
not.
of power, that was
I have not. I should be frank and candid to my lord. I have not. But I have specifically said that I don't want to withdraw the suit. That I have. And then, my lord, your lordship will kindly see paragraph 8, which is more important. By a minute of the meeting dated 1st February 2024, it was agreed on behalf of the plaintiffs to withdraw the suit, and the plaintiffs authorized the constituted attorney to take steps for withdrawal of the suit on the following terms. Here, my lord, I pause for a moment. I do not know when this meeting was held. I do not know which plaintiffs have given what consent. I do not have the copy of the minutes. I was not there. I have not given.
settlement is not within your knowledge.
Nothing within my knowledge. But it is being said that on behalf of the plaintiffs. I do not know whether this 1st February 2024 minutes have been, any copy has been given to my lord or not. We do not have anything. And my lord, one more thing. This meeting was held on, according to them, on the 1st of February 2024, and the terms of settlement after more than a year, 30th of April 2025. So I may presume that negotiations were going on with the defendant. I may presume. What? I put a question to them. What would stop them if the minutes everyone wants to withdraw on the 1st of February 2024? What would stop them from coming soon thereafter instead of waiting for more than a year? That's a question, my lord, which raises doubt. And my lord, from a document which is not part of my lord's record, it is a part of the record before the learned arbitrator in which an arbitration proceeding is going on. We have come to learn that much prior to this date, this constituted attorney has given all his right to some other partner. So at that point of time, the day he is signing the terms of settlement, according to us, he was not a partner at all. He had given all his rights that he had in the partnership firm to one Mrs. Sonali Roy, to one Miss Sonali Roy, who is also there. And my client's name is also appearing, my lord. Sujoy Mukherjee in the pen, by the pen of the constituted attorney, all the partners. And your lordship will kindly note that my learned friend, Mr. Shomava Ghosh, there are so many Ghoshes in this matter, my lord, I have to mention the first name. Mr. Shomava Ghosh had just submitted before my lord that my client is not a partner. The plaintiff, the constituted attorney, is writing my name here, my lord, Sujoy Mukherjee, by the pen of the constituted attorney. So everyone here, all the
client is this Prafullo Kumar?
No, my client is, my lord, Sujoy Mukherjee.
Sujoy Mukherjee.
Yes, the plaintiff number?
Yes.
10. So, my lord, it is accepted that my client is a partner till the terms of settlement has been filed. And now, my lord, only the one provision I'd like to place before my lord, that is Order 23, Rule 1, Sub-Rule 5. If I may hand over a copy of the Code of Civil Procedure. Order 23, Rule 1, Sub-Rule 5.
Order
23.
Order 23.
Rule 1, Sub-Rule 5.
Yes.
I'll not trouble with the entire, my lord, order and rules. Your lordship knows them very well. Only the last 5. Nothing in this rule shall be deemed to authorize the court to permit one of several plaintiffs to abandon a suit or part of a claim under Sub-Rule 1 or to withdraw under Sub-Rule 3 any suit or part of a claim without the consent of the other plaintiffs. So, my lord, my humble submission here would be that.
So this is not complied according to you.
My humble submission is that.
So they are to justify that it is complied.
Yes. And that, my lord, I have shown it to my lord, how prior to the passing of the order and prior to the so-called terms of settlement in which I was not a party, nor was I a party in the minutes.
You are not represented in the court also.
I'm not represented in the court. I'm being represented by a separate advocate. I've intimated that. She was not there. It was the impression was given that everyone is being represented. And your lordship.
And she filed power on your behalf.
Yes, on the 25th of April. I've intimated that much prior to the passing of this order. This order was passed on the 2nd of May. I have filed it on the 25th of April, pursuant to leave passed by this honorable court. And on that day itself, I'm informed. And my lord, one more provision, my lord. Order 23, Rule 3. Compromise of suit.
Yes.
Where it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties. So it has to be by all the parties. Here, when a party is a dissenting party, then that party is, my lord, without the dissenting party's approval, my humble submission would be, my lord, the suit cannot be withdrawn. This has to be read along with the previous rule that I had, my lord, placed, that it has to be by consent of all the plaintiffs. My lord, then a proviso is there. Provided that where it is alleged by one party and denied by the other, here they are alleging and I am denying, by the other, that an adjustment or satisfaction has been arrived at, the court shall decide the question. So, my lord,
this is not the issue. No question of satisfaction of the claim. Okay.
No.
The defendant has not alleged that the claim is satisfied or there is no cause of action. This is not. It is the terms of settlement, which is not by consent of all the parties.
I'm obliged.
This is the dispute.
I'm obliged. That is what it is. And my lord, my main point is, before having placed this before my lord, it was brought to their notice that I am a dissenting party. I do not wish to withdraw. So, my lord, this ought to have been brought to the notice of this honorable court before this order was passed. So that is where the misrepresentation and suppression of fact has taken place. And my lord, misrepresentation and suppression and fraud would vitiate everything.
Anyway, whether that is complied or not, that is your case.
My case.
That provision is not complied and they have to justify that it is complied with.
Yes, I'm obliged. May I file the affidavit of service?
Yes. Yes, Mr. Wolf. You are representing?
I am representing all the plaintiffs, 7 except my learned friend,
10.
plaintiff number 10.
10.
My lord, the entire jurisprudence that my learned friend has propounded by showing Order 23, Rule 1, Sub-Rule 5 and Order 23, Rule 3, that a compromise cannot be entered into without all the plaintiffs or all the parties being parties to it, holds good if the plaintiff or the defendant is not a partnership firm. He is absolutely correct that the jurisprudence is that. But partnership firm is a compendium of persons, your lordship knows. Its character is different. And the law allows in a partnership firm, majority of partners to, my lord, take decisions, including the withdrawal of the suit. And that, my lord, will be an exception.
So there was 23. A resolution in the partnership.
Yes, yes, with notice.
So if there is a resolution, it need not be whether other partners have agreed or plaintiffs have agreed or not.
Yes.
It is simply on the basis of that resolution, you have to come forward.
Absolutely. Kindly see section 12.
There's no question whether plaintiff X or Y has given.
And my lord, not only that, my lord, your lordship will be astounded as to who is the plaintiff number 10. I will come to that. Let me first show
whether who is plaintiff number 10 means whether plaintiff number 10 is a partner or not.
He's a partner.
Otherwise, what is relevant?
No, the relevancy is
yes.
that he is a convicted.
No, whether it
person,
is necessary to
he was behind
the
bars. Yes, kindly see.
If that is necessary, then only the
no, very important. I'll come to that very well. I'll come to that later. Kindly take section 12 of the Partnership Act.
Yes.
Section 12. Kindly see section 12. Conduct of business. Subject to the contract between the partners. A. Every partner has a right to take part in the conduct of the business. B. C and D kindly sees. Any difference arising as to ordinary matters connected with the business may be decided by a majority of the partners, and every partner shall have the right to express his opinion before the matter is decided, but no change may be made in the nature of the business without the consent of all the partners. This is not a change of business. Only if I change the nature of the business, consent of all partners is required. Every other matter in the ordinary course can be taken by the majority of the partners. 12C of the Partnership Act is a departure from Order 23 Rule 1 and Order 23 Rule 3. Clear answer to my learned friend's argument that he ought to have been made a party to this consent terms, and that without him the consent terms cannot go through. Clear. 12C. I have a decision. None other than my lord Justice P.B. Mukherjee, in his inimitable style, has categorically propounded the law. And my lord, also kindly take my lord section 19.
19. One line.
19. Subclause 2, C and D. Implied authority of a partner as agent of the firm. Subject to provisions of section 22, the act of the partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm. Then number 2, in the absence of any usage or custom or trade to the contrary, the implied authority of a partner does not.
Yes, that is page
19, section 19. This is, we do not have an implied authority to withdraw the suit. 19.2, D and C. No partner has the implied authority to withdraw a suit. But that is why, my lord, 12C has been engrafted by the legislature in the Partnership Act, that by majority decision, partners can take a decision on any matter relating to ordinary matters, save and except change of business. Change of business requires full consent of 100% of the partners. Except that, my lord, even a person who is a partner and he is declining to agree to the withdrawal of the suit, my lord, does not matter. But what would have happened? First of all, I will show that he had notice of the meeting in which this whole thing was deliberated. He did not appear or care to appear because he is a convicted person. He is more interested in defending proceedings against him in criminal courts. My lord, in that minute of the partnership, every other partner is present apart from respondent number 10, plaintiff number 10. And everybody has agreed to withdraw the suit in terms of section 12C of the Partnership Act. My lord, let us, my lord, take that he was there. Let us take he did not have notice. Let us say if a fresh my lord, meeting is today convened. What would happen if today, my lord, a fresh meeting is convened of the partnership? Though your lordship is not here to decide that, but say for the sake of argument, there's a fresh meeting of the partners. He comes and he opposes. 1:8. 1:14. 1:14 majority. Even today, the decision of withdrawing of the suit will be passed with a thumping majority. Thumping majority. That's number one. I have not hoodwinked the court. I have not played any fraud on the court. I have acted in terms of the rights given to me under the Partnership Act. That's the point number one. I have dispelled this whole theory that I have tried to hoodwink. No, I will produce those minutes. I will produce those letters. But law provides me to proceed on the basis of majority, and I have proceeded on majority.
But you should represent before the court. Not you do one thing and you represent something else. Everything should be transparent before the
court. But my lord, kindly see, my lord, what has happened. The terms of settlement.
If Mr. X has not consented, clearly show that Mr. X has not consented, but this is binding by majority of the decision.
My lord, may I say something?
If law requires a thing to be done in a particular way, definitely it has to be done. But it has to be done in a transparent manner. That is the thing.
My lord, one thing. A decision is taken by the entire board of partners, 7 except 1 person who does not care to come. And my lord, it is passed in majority.
This cannot be decided here.
Exactly what I'm saying. It cannot be decided by your lordship. My lord, what will happen if my learned friend's case is that he ought to have been consulted or this decision is bad of withdrawal? He has to sue the other partners in a differently constituted suit. How can he say that no, this decree will not be drawn up? How can he say that the compromise between the defendant and the plaintiffs is bad? He may say, my lord, and I do admit to that extent, that this decision that the partners have taken of withdrawing the suit is bad. He has to seek his remedy in a differently constituted suit against all of us in a different suit if he wishes to file it. Saying that I did not have knowledge, I did not, the resolution could not have been taken. This is not in the interest of
regarding that order 23 rule 5, it is not applicable to partnership firm as any decision.
Yes.
See,
kind of.
That is not binding upon all.
My lord, one or two things, my lord, before I show that decision. My lord, he says he did not have knowledge of this withdrawal. He says so. He has knowledge only after this order has been passed. That is not so. He had knowledge. This is just a ploy to arm twist the defendant and the plaintiff to get a more share than what he is entitled to. Why? Kindly come to page 185. Kindly come to page 185. And then I will immediately show the law thereafter. Lordship has got 185. Well, that is volume 2.
Page 185.
Volume 2, my lord. Volume 2, my lord.
Yes. Yes.
Lord, kindly see, on 13th of March 2025, my lord, the I'm sorry, my lord, the my lord, the partners, the partnership firm writes to their erstwhile advocate, because my lord, my contention in the terms of settlement is on 15th of February 2024. This meeting, this decision has been taken. My lord, I write on 13th March 2025, one of the partners, my lord, to Chatterjee Sheel and Company, our erstwhile advocate, that do not wish to proceed with the aforementioned suit. In such circumstances, you are instructed to take necessary steps. 13th of March. Then, my lord, kindly, my lord, see, my lord, 203. I say, after writing to, my lord, the erstwhile advocate, the plaintiff number 10, and even before that, had knowledge of this compromise being effected. Why, my lord? Kindly see page 208. Who is writing, my lord? 203. 203, my lord. This is signed by Sujoy Mukherjee, the plaintiff number 10. Kindly come to 203 and 204. He is writing to Chatterjee Sheel on 20th March. What is he writing? First of all, thank you for informing over telephone about the letter dated 13th March sent to your office by one Somsekhar Mukherjee claiming himself as a partner of Messrs. Ashutosh Roy, Prafulla Kumar Roy. In this context, I would like to inform you by this letter that I am nowhere authorized the said Somsekhar Mukherjee to issue the letter dated 13th March for withdrawing the above mentioned suit in such and such, pending before the Honorable High Court at Calcutta. Not only this, to inform you that as per my knowledge, the record Somsekhar Mukherjee is no more a partner of such and such. He already signed all his rights as partner to Sonali Roy, another partner of Ashutosh Prafulla Kumar Roy partnership firm. Therefore, as lawful existing partner of Messrs. Ashutosh Roy Prafulla Kumar Roy partnership firm, my humble request before you not to take any action before withdrawing the aforementioned suit on the basis of the letter dated 13th March 2025. Furthermore, kindly issue no objection, Vakalatnama in my favor. So, pausing here for a moment. 20th March 2025, my learned friend's client has noticed that a decision has been taken and a partner on behalf of the partnership firm has already instructed the erstwhile advocate to withdraw the suit. He, my lord, does not revoke the power of attorney in favor of the constituted attorney. He only tells the advocate not to act. So 20th March 2025, he has knowledge that we are proceeding. He keeps quiet. He is on the fence. Pardon me for using that expression. He's on the fence, seeing if I can extract a bit of more pound of flesh than what is due to me. 20th March, he creates the homework, the basic edifice of making this fraudulent attempt. 20th March, he writes just to the advocate, erstwhile advocate on record, please do not withdraw. Then, my lord, kindly takes, my lord, page 209. This is a letter of 20th April 2025, written by his lawyers. 20th April 2025, your lordship will get at page 210. I, the undersigned, have filed Vakalatnama on behalf of the client in subject proceedings, henceforth will be represented by the suit. As such, you are hereby requested not to take any steps in the suit for behalf of the aforementioned client, plaintiff number 10 anymore. You are also requested not to take any steps for withdrawal of the suit as my aforementioned client plaintiff number 10 is not inclined to withdraw the action, but to proceed with the same. So he is aware as far back as in April and, my lord, in fact, March, I have shown 20th March 2025 that the other plaintiffs are going ahead with the withdrawal of the suit. But, my lord, he does not, point to be noted, he does not withdraw or revoke the power of attorney given. Only, my lord, verbal communications. Create a cloud, create a doubt so that that can be utilized at the opportune moment. My lord, pausing here for a moment. If he was so much aware to protect his rights and he was absolutely sure by this time that we are withdrawing and he does not wish to withdraw, he could have come and filed an application. He has not done so. He has not even written a single letter to any of the partners saying that on what basis are you withdrawing. I have not got any notice of any withdrawal. I have not got any notice of any meeting held by you. Nothing. No, nothing produced, nothing written. He knew the withdrawal is taking place. He knew this was deliberated and decided by the majority partners. He just created an opportunity for himself. This should be deprecated. Then, my lord, kindly, my lord, now see, my lord, let us take his allegation at the highest. That yes, he was not aware, he does not wish to withdraw, and all the other plaintiffs all the other, my lord, partners of the firm wish to withdraw, and a compromise is entered into. What is the effect? My lord, Justice P.B. Mukherjee, as I said in his inevitable style, has, my lord, laid down the law. Kindly may I place, my lord, AIR 1954, Calcutta 409. And today, my lord, we are, my lord, on the question of whether, my lord, they need, my lord, or deserve any protection as of this date. Kindly see, my lord, just a few lines on the facts, exactly our facts. This is a plaintiff's application for a chamber summons to take the plaint off the file, or alternative to withdraw the suit with liberty to institute a fresh suit, or in the further alternative to stay the suit. The application is from many points of view a peculiar one. The suit was filed by the House of Limited Agency described as a registered firm as a plaintiff. Verification in the plaint is by Makhan Lal Shamadar, a partner of the plaintiff firm. Plaintiff is also signed by the said. The plaint is also signed by Makhan Lal Shamadar. Makhan Lal Shamadar is admittedly a partner. The present applicants claiming themselves also as plaintiffs are the other partners of the said plaintiff firm. The partners of the plaintiff firm are Makhan Lal Shamadar, Ramola Sarkar, Birendra Kumar Mitra, Kormorarani Bose, Hori Shankar Datta. Articles of partnership are contained in a deed such and such. Suit was instituted on 52. Claim in this suit is against a defendant company by the name Paints Lacquer Limited for the recovery of different sums of monies like such and such, such and such, and such and such. The smaller sums are said to be due by way of allowance. Present application is signed and verified by Birendra Kumar Mitra, one of the partners of the firm. In the petition, the main case is made on the ground. Kindly see, the majority of the partners considered that the suit is bound to fail and was instituted by Makhan Lal Shamadar without any justification or authority and without consulting the other partners. This is supported by a resolution of the plaintiff firm in a meeting held on 1952 and attended by all the partners except Makhan Lal Shamadar, who did not attend the meeting in spite of notice. Exactly our facts. The minutes of the meetings reveal that Makhan Lal Shamadar voluntarily resigned on such and such from the duties of the plaintiff's day-to-day administration. Not our case. This is in fact is corroborated by a letter by Makhan Lal Shamadar in 1951 and set out. 6. The resolution proceeds to state that the partner Birendra Kumar Mitra was thereafter entrusted with the day-to-day administration. And, my lord, next page, my lord, the resolution further states that the plaintiff firm never demanded payment. In fact, it was resolved that meeting that in the best interest of the plaintiff firm and the defendant company, the outstanding dues of the firm as settled and worked out by Birendra Kumar Mitra and the company would be realized in installments, and the defendant company would be at liberty to pay the agreed sum within a period of 3 years. But coming back to the facts, this is exactly what we have agreed. Whatever the defendant has paid till date will be given to the partnership firm, and the partnership firm will withdraw this suit. Because according to us, this suit does not have the merits to go to trial. Then, both in the minutes of the meeting as well in the petition, there are serious allegations against Makhonlal Shamadda. And it is alleged that he has been instrumental in launching different, not very important. Kindly come to paragraph 11. This is the law now being propounded. The provisions of the law of partnership with special reference to Indian Partnership Act may be examined in order to determine the questions raised on this application. Section 19(2)(c), which I referred to of the Partnership Act, provides that in the absence of any usage or custom or trade to the contrary, the implied authority of a partner does not empower him to compromise or relinquish any claim or portion of the claim of the firm. Similarly, 19(2)(d) of the Act, there is no implied authority of the partner to withdraw. Then, my lord, learned counsel for the Shamadda has relied on these sections and said that this could not have been done. Now, my lord, kindly see paragraph 13. This is where I am heavily relying on. The case before me is not the case where one single partner is compromising or relinquishing or withdrawing or staying any claim of the proceeding. The question here is whether the majority of the partners can do so. And the question here is not concerned with the partners' relations and third parties, but with the relation of partners inter se. I find nothing in the Partnership Act which can be construed and regarded as a statutory prohibition of the course of action now asked by the majority of the partners in this case on the present application. Kindly see on this question, it has been paragraph 14 argued that the provisions of section 19(2)(c) and d of the Partnership Act are a departure from the English law on the point, and reliance has been placed on the footnote in Dinshaw Mullah's commentary on the Indian Partnership Act. But I am not troubling your lordship with all this. Kindly see paragraph 16. Very important. Again, a proposition of law which is being laid down. In fact, the essence of a partnership is that all should act together, and if they cannot, the majority would prevail. This is what I am saying. To hold otherwise will mean that it is not a partnership, but the dictatorship of one of the partners. The specific clause in the partnership agreement in this case also expressly says that in case of difference of the opinion at any point of time, the opinion of the majority shall prevail. It may not be so, but not the act says so. In this case, while the partnership continues, there is difference of opinion whether the suit should be continued or not. And I see nothing illegal in the court upholding the express terms of the partnership contract. 17. It will be, in my view, a wholly unwarrantable aberration of the law of partnership and its procedure, as I understand them, to allow a partner who chooses to continue as a partner and not to retire, as in this partnership agreement, or to dissolve the partnership, to have the privilege of a partner of using the name of the firm as a plaintiff in litigation, and at the same time defy and break the express contract of the partnership. Then, my lord, kindly, my lord, come to paragraph 24. I am not, my lord, taking your lordship through the English laws. Kindly comes to what the learned judges hold after taking note of the English laws. In the present case before me, there is no allegation of any fraud or collusion as between the majority of the partners and the defendant company. So far as subclause C and D of 19(2) of the Partnership Act are concerned, it is clear in this country that there is no implied authority and any more after this statute for one partner to compromise or relinquish any claim. To that extent, the observation just quoted from Lindley are not applicable in India. But, kindly marks this, but then, as I have said before, subclause C and D of 19(2) of the Partnership Act cannot be interpreted to mean a prohibition on the majority of the partners to act under section 12(c). This is what I said of the Partnership Act, and under an express contract of partnership, providing that in case of any difference, their opinion shall prevail, and so as to discontinue the suit initiated by one partner in the name of the firm without the consent against the wishes of all the partners. 25, very important. Kindly see what weighed with the learned judge. The practice of staying the action in such cases raise the question of how long the stay is to operate. Either it has to be perpetual stay of perpetual injunction, restraining the suing partner from prosecuting his action in the name of the firm, or the stay has to be limited to such time as the suing partner furnishes the indemnity and security and decided the case are silent on the point. Such stay is, in my view, unfair to a defendant, Mr. Ghosh's client, to the action because it places him indefinitely in a situation where the suit is kept pending against such defendant. I see no legal justification or principle by which a defendant should be made to suffer this situation for the internecine quarrels between the partners in an action where the firm is the plaintiff and for which the internecine quarrels the defendant is in no way responsible. From that point of view, I would much rather adopt the course. Kindly see what is important. Adopt the course of ordering the plaint to be taken off the file. And if thereby the partnership suffers any loss in the matter of recovery of its dues, in this case, recovery of possession, the disappointed partner can be left to his remedy under the contract of partnership and under the partnership law, either to sue for dissolution or for retirement, as is the case with the claim for loss, if such there be due to the willful misconduct of the partners. I do not consider that indemnity for cost by suing partner is necessary. But this is the law, that if the majority has acted, one person or the minority cannot stop that action. That compromise has to go through. The defendant cannot make to suffer when the majority of the partners have agreed to withdraw. And, my lord, the disgruntled partner has a remedy of filing a separate suit against the partners. Let him file. But why should, when the majority decision under 12C is taken to withdraw, my lord, he has no voice. Today, even if he was there in the meeting, nothing would have changed. Even if he was there at the time of passing the terms of settlement by your lordship, nothing would have changed. That is the point. Today, my lord, a person who has been sitting in the wings for all this while, knowing that this action is in play, has come at the opportune moment when the terms has been agreed to. We have all taken stands to our detriment. Now he wants to, my lord, arm twist the defendant and possibly the plaintiffs to get something more. This kind of a litigant should not be encouraged. And this is not the first time, my lord. Kindly see, my lord. He was convicted at the instance of the defendants, my learned friend's client, and he has to suffer six months of simple imprisonment for my lord, forging his signature.
Not for a single day was he imprisoned.
That is
not for a single day was he imprisoned. I have adopted the practice of jumping up and my lord making submissions.
The question
Order. I am saying the order.
Yes, that's the stay order.
The firm has not removed him.
No, that is why I'm saying, even assuming he's a partner, and he's a partner.
No, it's an admitted position. He's a partner.
But even if he was there in the meeting,
yes,
it would
that's
not
a
have
different
mattered.
issue. Yes.
Majority. And even if he was there in court while the matter was disposed of and my lord, compromised, nothing would have mattered.
It does not apply at all. I'll take 2 minutes time.
Anyway, come on the next day. It's
next date, my lord, tomorrow?
Tomorrow or on Thursday.
But in the meantime, no steps should be taken as per the
If
order.
the lordship has not heard, kindly do
No,
not.
no. Then my lord,
But the entire thing will become infructuous.
Yes.
All before your lordship, we are not doing anything.
Yes,
The money is no order is required. Money is with the
order
receiver.
is required.
Record an order.
Order is
The
required.
money is with the receiver. Nothing is happening.
Order
We
is
are all
required.
before your lordship.
Learned advocate.
This is the
Yes,
answer.
Learned advocate for the parties are present. Heard learned advocates on GA 11 of 2025. As the hearing could not be concluded, let this matter appear. I'm keeping it on Thursday.
As your lordship.
বৃহস্পতিবারে 3 PM এ কোনো ম্যাটার ফিক্স আছে?
My lord, Thursday, my lord, we are all, my lord, very, my lord, uncertain. If it
I'm keeping it at 3 PM. That is why your day's work will be over.
Uncertain at 3.
But my learned friend has finished. I understand. Have you finished? Oh, I'll take my lord 10 minutes.
I believe my learned friend will.
So defendant, huh?
Defendant will say something.
Can it be Wednesday or my lord, Tuesday tomorrow? My lord, we'll finish as my learned
Wednesday
friend.
আছে? Wednesday আছে 3টের সময়? Wednesday 3টের সময় আছে, 2টোর সময়ও আছে Wednesday. দুটোতে কিছু নেই।
Come at 2.
Okay. Let this matter appear on. আচ্ছা আজকে কিছু ফিক্সড হয়নি তো বুধবারে 2টোর সময়? কারণ আজকে একটা ম্যাটার ফিক্স হলো 2টোর সময়। হ্যাঁ, 21 তারিখে 2টোয় আছে।
Then maybe come at 12:30 in the first half on Wednesday, if your lordship so feels.
Only urgent matters now onwards. No hearing matters.
Okay, 21/5/2025 at 12:30 p.m.
In the meantime, no steps
It
to be
is
taken.
expected that in the meantime, the parties will not take any steps.
Malad, we cannot. The decrees to be drawn up by your lordship's officer. The special officer is holding.
Parties
the
and
Do not rely upon this in
And the
any other
receiver.
forum.
Malad, nothing.
Now,
we
parties
cannot
and the
deny.
receiver. The receiver should also keep the money with
The
himself.
receiver cannot do anything.
He's got the money. He's got the money
Okay,
with
the
him.
parties and the receiver will not take any steps in the
I
meantime.
hope nothing happens. My learned friend is saying so. I take him for his word.
Your lordship will come back on Wednesday. Nothing will happen.
Wednesday 12:30.
As your lordship.
I'm sure.
Before lordship rises,
Something will
lordship
happen.
rises, item number
Yes,
18.
come at 2 p.m.
Deeply obliged, my lord.
Sanjay da.
2 PM better take it.
Your Lordship,
Another.
I appear on behalf of the defendant. I am being led by Mr. Dutt and Banerjee, Mr. Banerjee, praying for that the matter should be taken up after the vacation.
My lord, they have issued a letter, to be candid to your lordship. They had issued a letter yesterday evening. My lord, this application, I'll require a little time to place the case. My lord, let my learned
Which
friend,
application is to be heard out?
my lord, GA9. It's an application, my lord, seeking occupational charges since the defendant lessee is enjoying possession without making payment.
Okay.
Eviction too. My lord, I'll require a little time. Let me place my case. My learned
This
friend,
application is to be heard out.
yes.
Yes, Lordship.
You have filed your opposition to this.
Lord, this is my application.
Oh, your application?
Pleadings are complete.
Yes.
Let my learned friend take notes.
Learned advocate for the plaintiff and learned advocate for the defendant are present. Learned advocate for the defendant press for time.
My lord, defendant press for time.
Defendant.
Yes. My lord,
Press for
kindly
time.
allow me to place my case.
No, actually, they are not ready.
My lord, since pleadings are complete, I understand my his senior has some personal difficulty today. Let us come back.
So
tomorrow.
otherwise, no purpose will be served. They will not be able to submit.
My lord, let her take notes, my lord.
No, purpose will not be served. So again, I have to keep it after vacation because you see, before vacation, it will not be concluded.
My lord,
So
the
let this
DT is
matter,
suffering.
anyway, let this matter appear on 10/6/2025, second date after the vacation.
My lord,
10th of June.
very well, my lord. Any time, my lord, my Mr. Kaur was appearing, leading me.
Okay, at 2 PM.
Grateful, my lord. And my lord, may I file a supplementary affidavit in let them use any pleadings?
Okay, let the supplementary affidavit file be kept with the record.
Lordship,
And copy be served.
Yes. আমি না একটু রাখছি, পেজ নাম্বার গুলো মেলাতে হবে। মানে না না, এটা ফাইল অর্ডার হয়ে গেছে, এখানে অবশ্য পেজ নাম্বার গুলো একটু মিলিয়ে নেবো। My lord, I have already kindly record that I have already served. My lord, after today's session, I realized why my lord was pleased to direct us to come back with a proper application, so that all those facts could be brought before your lordship.
Anyway, take steps necessary. Yes, passed over matters.
Action motion passed over item number 9, Tabra Shahanat and another
Okay, not today.
10, Haji Muhammad Sirajuddin.
Lordship, I am for the petitioner plaintiff in this matter, Lordship. On the last occasion, Lordship, I had completed my submission. It was for them to start their application.
I'm being led by Mr. Singupta. Just 5 minutes passover. Can we? He's coming, my lord. He's in city court. He's
Okay,
just
item 10 passed over.
Lordship,
but only for
in
5
that
minutes.
case, can it be fixed at a time because I have another matter place? I can just come back.
Then not today.
No, Lordship.
My
But this is Lordship kindly takes up the matter. Lordship.
He will come.
Either let it be not today or passed over.
Lordship kindly takes up the matter, Lordship. Kindly, because
Just-
this it's a very old GA application, Lordship, and
Just for 5 minutes, my lord. He is just coming, my lord.
Okay.
grateful.
Look at item number 16. Your lordship fixed it, Lord, on 10th at 2 PM.
Yes.
Could it be on 11th at 2 PM instead of 10? I'll inform the other side.
Other side, you are here. You are.
No, he is appearing with me. The other side has just left, but I take the responsibility.
11 তারিখে কোনো ফিক্সড আছে? দুটোর সময়, 3টের সময়, 11 তারিখে। Okay, at 3 PM. 11 তারিখে 3 PM fixed আছে।
Then 9th is the
Reopening date.
Reopening date, 2 PM. If that is applicable. That is not inconvenient to your lordship.
No, but other side is.
Sir, I'll inform the other side. I'll inform the other side.
Okay, 9th at 2 PM.
Much over, much over.
Testamentary matters item number 12 in the goods of Ramata Durgesh Kumari.
Lord, this is an
Rajmata.
Lord, this is an application for revocation of the grant of letters of administration in favor of the applicant, my lord. Therefore, my lord, we taken up this application for revocation. My lord, Lord, on the last occasion directed us to file our written notes. Lord, Mr. Shomabu Ghosh was addressing your lordship. We concluded his submissions. Lordship had only requested us to file our notes, my lord. Lord, Mr. Ghosh is not here, my lord. He has only requested, my lord, he'll take 10 minutes of your lordship's time to conclude his arguments, my lord. Otherwise, my lord, the matter has been heard by your lordship, and the notes are also ready. My lord,
He will submit today.
my lord, could it be tomorrow, my lord?
Okay, not today.
Very good. My lord, we'll file our notes tomorrow in that event.
Yes.
I'm grateful.
13 in the goods of Sunil Kumar Chakraborty.
Okay, not today.
14 in the goods of Kokit Chat Nahata.
Not today.
15 in the goods of Ashrafi N.
Not today.
All suits item number 17. Bilashpur Casting Limited.
Not today.
18 John Grigori Apkar and another.
Lordship, item number 18, I am appearing on behalf of the wardens of the Armenian Church, Lordship.
Item 18.
Yes, Lordship.
Yes.
Wardens of the Armenian Church, my lord, this is a suit of 1888. There were some disputes between the Armenian community, and few of them had filed this suit, Lordship. Under this suit, the scheme was framed by which the properties of the Armenian Church would be administered. The official trustee of West Bengal was formulated accordingly, who would, in hands with the Armenian Church, would maintain the properties held by
Who are the
Armenians.
present applicants?
I am the wardens of the Armenian Church currently.
These two persons are
They
are
were
still alive.
no idea, Lordship. It's an 1888
So you
matter.
check up the records. What is
Lordship,
the present stage?
the suit I'll tell you the present stage, Lordship. The suit was decreed. The scheme was formed.
Yes.
Now the scheme is changed from time to time. There are some changes, some modifications. So liberty was given to the parties to approach this court whenever there is an amendment. So whenever there's an amendment in the scheme and a GA is filed in this suit itself for such amendments. The last amendment was in 2012, Lordship. So whenever there's an amendment, the parties approach this court. So this suit has to remain alive, Lordship. Although there's nothing to be adjudicated in this suit, but because there are some purposes which are to be served and parties.
Now, what order is to be passed now?
Lordship, the suit can go out of the list, Lordship. Because there's really nothing my lord can do at this moment. If anybody has any changes or any modifications in the scheme, they'll file an application in this suit.
No pending applications are there in this.
Currently, no pending applications, Lordship.
Okay, you are representing whom?
The wardens of the Armenian Church, Lordship.
That means they are the applicants.
They were the defendant in this suit, Lordship.
They were the defendant.
They are the defendant, one of the defendant in this suit. The other defendant is the Advocate General, Lordship. So that does not apply, and the plaintiffs, we do not believe where they are or what is up with them.
It's a very peculiar question.
I'm led by Mr. Das Gupta.
Armenian people, there are very few of them left in India. For their interest, this charge was there.
These two persons, these are the original plaintiffs.
Yes, my lord. At that point of time,
John Gregory and Thomas Malcolm, original.
Between them, there was a dispute at that point of time in 1888. So suit was filed regarding who will take control of the church. Huge properties.
You are representing one of
I am representing the wardens of the church.
Wardens of the church.
Yes.
Present.
Now they are handling in association with the official trustee. That this honorable court has framed a scheme. Under the scheme, me, the wardens and the official trustee are working together.
So it was amended in terms of order dated 2012.
Last time. That scheme of 1886 that kept amended many a times. Last amendment of 2012. Since then, we are operating under that scheme. Many times matters come before this court regarding the scheme.
Modification.
For further clarification, for some special prayers before the court, in order to deal with some properties of the church. We come to court and seek permission.
Anyway, at present there is no prayer or application with regard.
But this suit needs to be kept pending because the suit is disposed of. Yes, but in that scheme will also go. So it cannot be disposed of. It should be kept pending.
Decreed but not disposed of.
This kept pending, decreed but kept pending. Decree the scheme.
No, decreed, the suit was decreed by formulating the scheme.
Yes. Now, the option dispose of the suit.
Now, from time to time, these schemes are modified.
Yes. For that purpose.
Originally, if the suit is decreed, it is disposed.
Yes.
Then thereafter, in terms of the as per terms of the scheme,
Yes.
it is modified time to time.
For that limited purpose, suit is alive. But we have to keep the suit alive, because otherwise, next time some fresh suit has to be
So
filed.
there are
fresh scheme.
different types of suit. 1930,
Yes.
1940. There are several suits.
Those
like
special suits are kept alive for these special purposes
trust
only.
properties and Devotar properties. Some
Devotar
suits are
property.
there.
It's one. In fact, this is also kind of Devotar property only, because it's for charge property. But that principle will not apply.
The suit may go.
The suit may go out of the list with
Yes,
liberty to parties for mention.
Learned advocate representing the
wardens
of the Armenian church are present. The Armenian church is presently run by these wardens who are the official trustees.
No, in association with the official
trustee. In association with the official.
Trustee is the one who take care of that everything, and we are
in association.
We are the owners.
In association with the official trustees. The suit was already disposed and a scheme formulated.
No, not disposed, decreed.
The suit was decreed and a scheme was formulated, and the said scheme was modified from time to time. And the last order of amendment passed by this court was on 2000. Do you know the date?
Exact date I can't give. 2012.
On 2012.
Exact
Stop.
date I can't.
As no application for any relief or amendment of the scheme is pending, the matter may go out of the list with liberty to mention.
Yes. Liberty to any interested parties may from time to time mention. Grateful.
Let the scheme filed, let the amended scheme filed be kept with the record.
Grateful.
Where is the location of this Armenian church?
But there are many properties. The church is at Girish Park. It's near Girish Park metro station, but the properties are there in all over North Calcutta. The Park Street, there are 2 properties in Park Street. I know the litigation is pending, mostly occupied by third parties. So the proceedings.
Chinsura also.
There are some now. Chinsura, yes. Chinsura properties are also there under the same. Very few members are left. They are all living in India. As the Armenian people, they came during that time.
There are very few.
Very few now. Very few. Maybe in hundreds in all over India.
All over India.
And they are run. They are. All of them come under the same.
Anyway, by scheme, this the
properties are maintained.
They are to be protected.
Yes.
By
So
this
they also get money from tenants and occupiers. That's how they are managing the trust.
That is how it has to be protected. Okay. Anyway, I have granted liberty to mention.
Yes. Grateful.
Yes.
Item number 19, Lakhi Devi Nathali. Item number 21, 21st Century India Limited. GT Road. No, sorry. GT and Company. 23, Virendra Sangvi. 24, Rajasthan Explosives. 25, Chumoti Chand Dakalia. 26.
My lord, I am for item 25, my lord.
Item 25, yes.
My lord, I am for the defendant number 2 and 3.
Pass it over. Mr. Subhashish Dasgupta is appearing in this matter. He's just on his way, so can you pass it over?
Okay, 25 pass over. Acha, call the testamentary passed over. Yes, call item 11.
Item number 11.
Yes, item 11 is your matter.
10, Lord. 10.
Yes, call item 10.
Item number 10.
Minus 10.
Haji Mohammed.
Minus, may I start in the meantime? Minus, their application is basically for setting aside the report.
Or
filed
can
by
you
the-
come ready tomorrow? I can keep it at 2 p.m. এই কাল দুটোর সময় আছে কিছু?
Mr. Sengupta is coming, my lord. In the meantime.
Okay, you start.
Yes, my lord.
Yes.
Before your lordship takes this matter up, item number 26, the OL was directed to come and furnish a report. No such steps were taken. It will just take 2
Anyway,
minutes.
this matter will also not take much time.
I thought his lordship is going to go. That's it.
Because their application is basically for my lord, setting aside the report of the partition commissioner, and my lord, their pair is also for my lord, framing the scheme on the basis of a draft plan that has been prepared by them only. So my lord, that draft plan has been prepared unilaterally by them, and there is no participation on behalf of us. And that is also beyond the my lord, preliminary decree. And the my lord, draft plan as my lord, annexed in 107 of the my lord, paper book. This is paper book 1, volume 1, 107.
Yes.
No, so the property is at the my lord, junction of my lord, Srinath Babu Lane and Heirs Lane. And my lord, kindly note their my lord's allocation was previously they are occupying my lord, the back portion of the property, and that is admitted case. My lord, we are the my lord, erstwhile plaintiff. The my lord, original plaintiff died. Our predecessor interest. So my lord, their first allocation was my lord, in the my lord, on the back portion of the property. So my lord, this partition suit has been filed, and my lord, thereafter their claim was that they should be allocated a front portion.
No, original preliminary decree was passed when?
It was passed in 2012.
2000?
That is at page 36 of the paper book, volume 1, lordship. That is on the 15th of February 2012.
Yes.
Yes. So 15th of February 2012, the preliminary decree was passed.
May your lordship with the leave of the court. Next. On the last occasion, may I just indicate what my learned friend has indicated. Undisputedly, the suit is for partition. Initially, my client's predecessor in interest have filed this particular partition suit. Thereafter, after the death of the original plaintiff, the heirs did not take any steps, and therefore the original defendant, he took the steps for the setting aside of the abatement and for the transposition of his name in place and stead of the plaintiff. And Justice Mojumdar's order very clearly said, abatement has been set aside and my learned friend's client has been transposed and I have been implemented today as a defendant. There are certain facts which are admitted.
So the plaintiff, the present plaintiff was a former defendant.
Former defendant. And my predecessor in interest was the original plaintiff. Now, in this particular suit, there is a preliminary decree which has already been passed declaring the shares. Your Lordship, kindly once take the preliminary decree which is at page 36. Page 36, order dated 15th of February 2012. Your Lordship has got it?
Yes.
This is a suit for partition. Only one property is involved, that is premises number 6, Srinath Babu Lane, Calcutta 73. The parties are ad idem regarding their shares in the property. The plaintiff would get 3/4 of it and the defendant 1/4. So there is no dispute regarding the shares. But the defendant has one condition. he should be allotted the front portion abutting on Srinath Babu Lane, Calcutta 73, to which the plaintiff agrees. So we have agreed that we will give him the front portion abutting to Srinath Babu Lane. But how much, where, it is not mentioned. Therefore, I pass a preliminary decree for partition inter alia on the above. Mr. Sushil Kumar Mishra, Advocate Bar Association, is appointed as a Commissioner of Partition at a consolidated remuneration of such and such to be shared by the parties. So till then, there was no problem. Appointment of the Commissioner has been done. Now, Commissioner has been appointed. Now, Your Lordship kindly sees there are 3 reports. The first report.
So this was the original plaintiff and the original defendant.
Original plaintiff and the original
After
defendant.
the preliminary decree was passed, there was some setting aside abatement and transposition of the defendant to plaintiff.
Yes, yes. There is no dispute that I am entitled for 3/4 and they are entitled for 1/4. There is no dispute.
Yes.
Now, before showing the reports, Your Lordship kindly take page 53, her application, which Your Lordship is presently considering.
Page 53.
Page 53.
Yes.
Page 53 is the application filed by her, and Your Lordship kindly take page 64. Your Lordship, the prayers which she has sought for.
Yes.
Page 64, the final report, scheme 4 of partition submitted by the Learned Commissioner of Partition, herein on 18th of December 23, be disregarded and not taken cognizance of, and no partition to be effected in terms thereof. So therefore, she is objecting basically the scheme 4 of the partition and not scheme 3 of the partition. The final scheme of partition be prepared and effect on the basis of a plan being annexure D hereto.
So final, that means scheme 4 of partition is challenged.
Scheme 4 is challenged. I'll show one by one. There are total 4 schemes. 3 reports given where the 4 schemes have been prepared by the Learned Commissioner for Your Lordship's consideration. See, she has made alternative the Learned Commissioner of Partition be directed to engage a different surveyor and prepare a final scheme of partition strictly in accordance with the preliminary decree dated 15th of February 2012 and the spirit thereof. Now, after this is the prayer in her application which is under consideration before Your Lordships today. Now, one order has been placed before Your Lordship and the impression has been given that everything has been decided, the order has come to a finality by Justice Samaddar, saying so, Your Lordship, that this particular draft, whatever this map they have given, the Honorable Court has already accepted it. I've seen that her submissions which she has made. Your Lordship, kindly take Justice Samaddar's order once. Order number. I think page 109. 109. Lordship, kindly take page 2, 109. And this order has been passed in this application. Volume 2 of the paper book, page 109. Page 109.
Yes, volume 2.
109. This order has been passed in this particular application. The Lordship kindly sees what order has been passed. The Commissioner of Partition appointed in the instant matter is directed to prepare a scaled plan based on the draft plan being Annexure D at page 84 of the application. Such scaled plan may be submitted before this court within 1 week. Let this matter appear for further consideration under the heading 1 week. Hence, till such time this application is disposed of, let the decree of final partition be not drawn up by the department.
Oh, is this order implemented? Is this order subsequently modified?
Lordship, this order has not been subsequently modified, but
no, neither it has been taken up before the higher forum.
No.
So this order is there, okay?
This order is there.
Yes.
But Your Lordship, this order does not say so that the final decree will be passed on the basis of that sketch plan.
Whatever is there.
Yes.
Let this order be acted upon.
No problem. But your lordship, on the last occasion, my learned friend has made a submission.
Order is clear. Okay, whatever is there in the order,
This
let
sketch
that be
plan,
done.
preparation of sketch plan. This is not for the acceptance by the honorable court. That's exactly my prayer is.
The question is to prepare a scale plan based on the draft plan. So what is directed is a scale plan be prepared and such scale plan be submitted.
Correct.
So let this be done. So this was not done.
This has not been done.
So let this be done.
Yeah, I don't have any problem if this is done. But your lordship, I am just making my stand clear before the honorable court that the honorable court has not considered those three reports of the learned commissioner. The submission has been
done,
made.
Okay, whatever is done, okay, let it be done. Thereafter, this court will.
Now, your lordship kindly sees. Lordship has passed an order. Where is this page 84 of your lordship this map? That is at page 107, if I am not wrong. What is it?
10.
No, from the paper book.
107 of the paper.
Page 107 of the paper book. If she is agreeable, I could not find page 84 in the paper book, but I think page 107 is the proposed plan. If I'm not wrong, lordship, kindly take page 107.
Yes.
Then I'll make you lordship understand what has actually troubling them and troubling me both.
107.
107.
Yes. Proposed draft plan, and page 84 is any proposed draft plan.
Yes, that's the proposed by her. This
Page
is not.
Where is page 84?
Page 84, your lordship is having only the paper book, not the application.
Oh, page 84 of the paper book.
Page 107 of the paper book and page 84 of the main application.
Page 84.
Application. This is not a commissioner's plan. This is a proposed draft given by them.
No. On the basis of the draft plan, the order says on the basis of the draft plan.
Correct.
Yes, this is proposed draft.
Yes, this is
page 84.
Proposed draft given by the present plaintiff.
Yes. So
this is not a commissioner's report on the basis of which the.
On the basis of this, what is done, the commissioner is directed, okay, to prepare a scale plan. So on the basis of this, a scale plan is to be prepared. That scale plan has to be submitted before this court within 1 week from date. Thereafter, the matter will be taken up.
Correct, for consideration of entirety.
Okay. Let it be done.
No problem. We don't have any problem regarding the preparation of the scale plan. The last day's submission was this is finality and scale plan has to be accepted. No, let the scale plan be prepared and thereafter your lordship will consider. May I just indicate 2 or 3 things and then I'll certainly this order has to be finalized, or rather your lordship complied with. Your lordship has seen page 107. Your lordship will first see the sketch plan. The first report is at page 87.
Page 87.
This is the first report given by them.
Volume 1.
Volume 1, page 87. I'll show only the sketch plans and I'll compare with 107. Page 87 is the first report given.
Yes.
And your lordship will see the sketch plan, that is the scheme number 1 is at page 93.
Yes, 93.
Page 93.
Yes.
Lordship has got? Yes. Now your lordship kindly sees what the first report said. They have given them the front portion 5 by 3.
That is there. Okay. Whatever is there, that can't be altered.
Yes, your lordship.
Only thing is this in terms of this order. Let some needful be done.
No problem. Your lordship can direct it.
After considering that.
Yes. We will
the matter will come up.
Then your lordship will actually decide the matter in entirety. Yes. Whether the scheme number 1, 2, 3 or 4 or this particular 107 should be accepted by the honorable court. That's my only submission.
Yes.
But that particular commissioner is not here, is not coming.
Partition commissioner needs to be appointed, Lordship, because the
Anyway, yes.
that is also there, Lordship.
So it's replaced for na?
There's a pair or
Learned advocate for the
the
parties
commissioner
that
particularly
present.
discharged.
Hard learned advocates on GA 376.
GA
G
376.
376 now it is renumbered as GA number 5.
Renumbered as GA number 5 of
2014.
2014.
2014.
14, Lordship.
Upon hearing the learned advocates and upon perusing the order dated 10th February 2024 passed by Honorable Justice Vishwanath Shamaddar, it appears that His Lordship was pleased to pass the following order. Quote, page 109. ঠিক আছে? Quote. Although the said order dated 10th February 2014 is passed, but no steps are taken by the Commissioner of Partition till date. Stop. In order to decide the matter in its entirety, this order is to be complied and necessary steps is to be taken to prepare a scale plan based on the draft plan being annexed D at page 84. In the facts and circumstances, this court is of the view that a new partition commissioner should be appointed to take steps in terms of the order dated 10th February 2024. Thus, Dash is appointed as the partition commissioner. The learned partition commissioner shall consider the preliminary decree as well as the order dated 10th February 2014 and upon preparing a scale plan based on the draft plan being annexed D at page 84 of the application, learned commissioner shall submit a report on or before 24/6/2025.
It takes some time, but your Lordship will is
24th is almost more than 1 month.
I don't have any problem.
A copy of the petition shall be furnished to the learned partition commissioner. The learned partition commissioner is entitled to take the help of a surveyor in preparing the plan and the necessary expenses to be shared by the parties.
Yes.
Let this matter appear on 24/6/2025 at 4 p.m.
4 p.m. No problem. Only one Lordship maybe line be added. The commissioner who is appointed will not only consider the preliminary decree and the draft plan, and also your Lordship the earlier reports filed by the commissioners, because there
Anyway,
are three.
No, I've just made it preliminary decree and this one, because so far the order is concerned.
Then your Lordship, he cannot direct your Lordship the surveyor, if I am not wrong. So he has to consider everything if
No,
Lordship kindly sees.
preliminary decree, and because so far this order says, okay, order says is this draft plan.
Page 84 of the
Yes,
application.
so only, I am just only adding this thing, preliminary decree and this draft
We'll
plan.
come back, your Lordship. Apprise your Lordship.
Yes, 24th on at 4 p.m.
Worship, if the present situation may be sketched out in the application, in the report file, Lordship, because there has been some discrepancies between the parties regarding the possession area and all.
That will be
certain
considered,
constructions
okay.
made.
Finally, that issue will
I
be
don't know why
considered.
she is fighting 1/4 share. If she wants 1/4 shares valuation, I can give it. I am 3/4 share.
Lordship, I am not on that, but there are certain only to the extent that Lordship.
Anyway, I made it clear that a surveyor may be appointed. Valuer is required.
Because if a sketch.
Surveyor is required, your Lordship. Otherwise,
valuer.
No, valuer is not required.
At present, not
At
required.
present, not valuer. Surveyor is required to.
Ascertain this present sketch, because Lordship, there are certain possession problems going on.
Made it
Certain
clear, I made it clear. Surveyor can be appointed.
Yes, yes.
Grateful, Lordship.
Lordship, Lordship, I appear on behalf of the plaintiff. On the last occasion, Your Lordship will kindly look at the order which Your Lordship had passed on the last occasion.
The 26 is passed over.
No, Your Lordship, I am appearing for the plaintiff at 26.
Okay, 25. 25 passed over.
Dinesh Metal লিখলাম তো
No, no, একটা matter mentioned করলো. Yes, one matter was mentioned by you. Passed over matter.
25 was passed over on the ground of Mr. Sengupta. I sought for
Okay,
a
okay.
he is there, Your Lordship.
No, 25 was no. Mr. Sengupta's matter was earlier matter.
No, so 25 also the Mr. Sengupta's matter.
In 25, both parties are present. Okay, let 25 be taken up.
Lordship.
মানে plaintiff হিসেবে
But I am on behalf of defendant number 2. In this matter, there are 3 GA applications which are at my instance. GA 12, GA 13, and GA 14.
All 3 applications are yours.
Yes, my lord. All 3 applications are at my instance. GA 13.
You want to do GA 13 first?
Yes. My lord, GA 13, if my lord. Yes. Now, GA 13, if my lord may kindly take up last order dated 8th of March 24. Well, this is an application at my instance.
8th March 2024. Degi?
Yes.
Yes.
13. Your phone? Oh. Yes, sir. My lord, report, my lord, may I read the order? Report dated 13/12/23 was filed, my lord. But this application was filed by me on behalf of defendant number 2 for a release of the fixed deposit which has been made at the direction of the court under order dated, my lord, 14th July 2008. Wherein, my lord, receiver was appointed. There was an agreement between the parties, and, my lord, a status quo was directed to be maintained, subject to deposit of the amount at the direction of the court. My lord, that was 39 and odd lakh rupees, my lord. That was to be made to the receiver, and receiver was to keep the same on the fixed deposit account, my lord. Fixed deposit account. My lord,
Your Lordship, I think, Your Lordship, unless and until the joint receivers are directed to be present, Your Lordship.
my lord,
so kindly
yes,
please-
I am coming to that. I'm coming to that. I'm going to that.
Their presence is required.
No, I just before
Yes,
going to the order, I need to
the
make.
joint receiver report was
Yes,
filed.
my lord. The joint receivers were directed to file a report, my lord. After the filing report, we filed an exception to that. And, my lord, there was an order on 8th of March seeking a clarification from the State Bank of India main branch, my lord.
Yes.
And receiver was under direction to send these orders, and my lord, a copy of this exception may be sent to the branch manager of State Bank of India, Personal Banking Division, Kolkata main branch, to submit a breakup and yearly accumulated interest since inception of the FD amount and deduction, if any. The report shall be in the form of a statement of accounts in respect of fixed deposit number such and such. The learned joint receiver shall serve a copy of his report as well exception to the branch manager for preparing the report. And what has been done by the receivers, we have not been intimated. Neither the plaintiff has been intimated, neither the respondent has been intimated. Nobody has been intimated what he has done, my lord. On the last occasion also, my lord, I was making a submission before my lord for a direction for joint receivers to appear before my lord and give an explanation to this what has been done. But till date, nothing has been done. Well, in such situation, let the joint receivers be directed to appear before my lord, give an explanation to this, and my lord, the branch manager be also be directed, my lord, whether he has been served with any notice, what has been done.
So copy of this application is served upon the receiver.
Yes, my lord, this was done in presence of the receiver. This order was passed in presence of the receiver because they have filed a report. We have filed an exception to that, my lord, and this order was passed in the presence of receiver, my lord.
Exceptions to the report was filed.
Yes, my lord.
So
It is stated in the
regarding that exceptions copy is also served upon the receiver.
Yes, my lord. Yes, my lord. That is why, my lord, it is stated that the exception, my lord, if the first line of page number 2 of the order, my lord, except the learned joint receivers might have siphoned off amount, since according to the exception, the fixed deposit amount should have been such and such as on itna. The report of learned joint receivers shows that fixed deposit amount is such and such as on itna. My lord, there are several other issues which we have raised in GA number 12 of my GA 12, my lord. But first, these
So
need to be
affidavits are not filed with regard to this application.
But
Although
with the
liberty was
application,
given.
my lord, it has already been more than 2 years. Neither the
No,
plaintiff.
although you see liberty was granted.
Yes, my lord. My lord, the conduct of the plaintiff also, my lord. Let me say. The conduct of the plaintiff. My lord, 3 applications at my instance, GA 12, 13, and 14, my lord. GA 12 filed in 22, 19th of May 22 till date, my lord. No opposition has been filed. GA 13 till date, even in spite of giving several opportunities, no opposition has been filed by the plaintiffs. My lord. It is only to the GA 14 which they have filed.
You are for?
I am for the plaintiffs. Lordship, this GA 13, your lordship, the prayers are not effective at all, your lordship. Second one, GA 14 is an application in the nature of 340.
Yes, sir.
So I have filed my opposition. And your lordship, GA number 12, your lordship, I require your lordship some time, your lordship. I understand, your lordship. Because we are the new entrant, we will file our affidavit. Very serious allegations against the joint receivers, your lordship. Next date, the joint receivers may appear. And your lordship explain. And in the meantime, we'll complete the pleadings. And 340, your lordship, doesn't lie, your lordship. I'll show your lordship the
That's
judgment.
a different issue, but 340 is not against the receiver.
No, that's against me. That's against me. I'll contest that.
That is why, my lord, only plaintiff have filed their opposition to that, my lord. GA 12, the allegations are against the receiver. Plaintiff have chosen not to, but the right needs to be closed, my lord. Even the receivers have not come with any opposition to that. They have not raised any objection to that, my lord.
Because reports have not actually given it to the plaintiff, so we could not take the exceptions.
If we go by, my lord, in the meantime, my lord, if my lord may, GA 12
report is not given by the receiver
yes, my lord,
to the
all the
plaintiff.
parties.
No, that's our instruction, your lordship. We have not got the, your lordship, the report.
Which?
The report filed by the receivers.
To GA 13.
GA 13.
It was exchanged in the court. It was exchanged in the court.
Which is in question in the suit. Your lordship, as far as GA 12 is concerned and GA 13 is concerned, first GA 12 seeks the removal of the joint receiver. GA 13 seeks and the fixed deposit that the receivers were required to make. So previously an order had been passed by the Honorable Justice Sanjeev Banerjee in this matter, your lordship, on consent of all the parties, wherein these receivers were appointed, the conveyance of the property was made in my favor, and the receivers were appointed to realize the rents and the issues and the profits from the property. And a fixed deposit was to be held in their names in the State Bank of India, the High Court branch, if I'm not mistaken, subject to correction.
Yes, absolutely.
So, your lordship, these two applications, J12 and J13, seek A, those receivers be removed on account of various allegations such as them not having furnished the accounts properly, or them having allegedly been in cahoots with.
So now we are hearing GA 13 and 14.
13, your lordship.
13 and 14.
GA 12 also, my lord. GA 12, all three are in the streamline, my lord. GA 12 are on the allegations on the receiver, removal of the receivers, what has been done, what has not been done, my lord. In the meantime, pending direction upon the receiver to personally appear before my lord, let there be a direction, let a special officer be appointed, inspect the premises, file a reports about the occupancy, who are in occupation of the premises, of which the rent is being
Already, your lordship,
collected.
the joint receivers are there.
My lord,
Let them first come and your lordship explain. Otherwise, how a
that is why
second special officer be appointed?
Prior to filing of their objection, let a special officer be appointed, let a report in respect to the occupation, because what we have alleged, my lord,
Then
the occupations, my lord,
then
let
have to be
the
removed, your
occupations, my lord, let the occupations at the premises has been changed without the leave of the court, my lord.
So that's a
This is the subject
allegation.
matter of which application?
G12, my lord.
Let me see that application.
My lord, rent receipts issued in favor of the plaintiff, my lord.
Because there's no such prayer for appointment of a special officer.
GA12.
GA12.
Okay, what is the prayer? No, GA12 is for?
For removal of the.
For removable. The prayers are of removal and appointment of new receiver and call
No,
for a
when
report
this
from them.
application is pending? 2022.
Yes, my lord.
And no opposition is filed
No
by.
opposition filed, my lord, time and again.
By the, you are for defendant?
Defendant number 2, my lord. This application is at my instance, my lord.
If I may indicate, whilst I'm for the defendant number 1 and a respondent in this application, technically, I am very much a supporter of this application and would like leave to file an affidavit in support there of this application. Because I am aggrieved by the actions of the receiver as well, because especially my rights, because I am the person who notionally owns the property. My rights are being extremely prejudiced, as it were, by the actions of the receiver. So I also seek leave to file a supporting affidavit.
No, from when did you come to the picture?
Your Lordship, I've been briefed very recently, Your Lordship.
No, not you, your client. Are you, so right from the very inception?
Since inception.
Because the conveyance was executed in favor of the defendant number 1. The registered owner of the property in question is the defendant number 1.
What is your grievance? That is, many other occupants are there inside the.
Occupants were there, my lord. Preliminary single receiver was appointed. Now, my lord, presently presiding judge of separate High Court, my lord, Justice Arindam Sinha was appointed as the first receiver in the matter, my lord. A preliminary report of the occupancy of the premises was filed by my lord, the then receiver, my lord.
Now, who are learned members of the
Learned
bar?
members of the bar,
at present?
Bar Association and Bar Library are the joint receivers appointed by my lord. And in 2013, there was a change. Since then, they have been, my lord. Now, since then, my lord, there has been several change in the occupancy. Several members have left because the report which was filed by the initial receiver does not match with the present occupancy. Because several bills have been issued by the receiver in the name of the plaintiff companies, which we have annexed to this GA12 alert. The plaintiff have till date not filed any opposition. My learned friend has been briefed recently, but in 22, the advocate record was there. They had appeared. They were represented by senior counsel, 3 years in line, Today we are on 19th of May. 19th of May 22, this application was filed,
So your grievance is paragraph 221. Persons are there occupying these premises.
These are the.
No, prayer G, your prayer G.
Yes, prayer G to GA12,
Prayer G of your petition.
The outgoing receiver be directed to justify the existence of person entities in various portions of the said premises as mentioned in paragraph 2 of 19, whose names have not mentioned in the report. Yes, madam. If page 19, yes, madam. Page 19, if we take up, madam. Yes. Yes, yes. Paragraph, yes, page 16, which starts, and page 17 contains the name of the occupants, which is in accordance to the report filed by the preliminary receiver, my lord. And
So their name did not figure.
now these were the original occupants.
No, page this thing,
Page
21.
17.
Yes.
Page 17 to GA 12, my lord,
Yes.
were the occupants as per the report of the preliminary receiver, my lord.
Yes.
And at present, my lord, the rents which are being collected by the joint receiver is in the manner at page number 19, my lord, which is to paragraph number 20, Roman 23, my lord.
Yes. Paragraph 19. Paragraph 19, not paragraph.
Not paragraph, page 19. my
Page
lord.
19.
Page 19, which contains a tabular statement, my lord, and which goes on to page 20, 21, and so on, my lord. How the rents have been collected. Zoom Supply Private Limited is one of the plaintiffs to the suit, my lord.
Okay, let the receiver appear on the next day, or
Yes, my lord, let the receiver be appear, my lord. Only at present, my small prayer, my lord, let a special officer or be appointed by this learned court to file a report as to who are the occupants.
regarding paragraph.
No, my lord, as of paragraph, I have not prayed for appointment of a special officer, my lord. I leave it to my lord.
Regarding.
This is again regarding my lord, occupancy. These are the at page number 17, my lord, who were the these then occupants, my lord. Whether these occupants are still there or not, or who are in the occupation, my lord.
Yes. Learned advocate representing the defendant number 2, petitioner, learned advocate representing the defendant number 1, and learned advocate for the plaintiff are present. Heard learned advocates on GA 12 of 2022. It appears that GA 12 of 2022, in GA 13 and 14, GA receivers was directed to submit report.
GA 13
Only
was
GA 13 here.
only GA 13, which
14
was for the refund, my lord.
Yes.
Which we had prayed to submit the status of the fixed deposit, and we wanted the refund of the FD, since the status quo in the main suit which was granted was only a paper status quo, my lord, and nothing
With
else.
regard to GA 13 of 2023, with GA 14 of 2023, it appears that pursuant to the order passed on 8th March 2024, whereby the learned joint receivers was directed to serve a copy of his report as well as exception to the branch manager for preparing the report. Nothing appears as to what steps are taken due to non-appearance of the receiver today. However, a copy of the order dated 8th March 2024 be once again communicated to the learned joint receivers to take necessary steps in terms of the order, said order, and submit a report by June 25, 2025. The petitioner in GA 12 of 2022 has sought for the removal of the joint receivers on the ground stated therein, which this court is of the view should not be done without granting any opportunity of hearing, an opportunity to file affidavits by the receiver and the other parties. Thus, you have served all this copy upon them.
Yes,
Thus, the learned receivers are granted opportunity to submit affidavit with regard to the said application GA 12 of 2022. As submitted by the learned advocate, that pending hearing of GA 12 of 2022, a special officer be appointed to cause inspection as to the occupants in the suit property as mentioned in paragraph 2 within bracket XXI are occupying the suit premises or not, and if not, who else are occupying the suit premises. This court is of the view that in the interest of justice, this order may be passed. Thus, Dash is appointed as a special officer to cause inspection of the suit property and ascertain as to who are the occupants there, and further as to the occupants as mentioned in para 2 within bracket XXI are still occupying the suit properties or not. The learned special
is appointing special officer.
Yes,
right?
yes, for this limited purpose.
There is no prayer as such, Your Lordship.
Anyway, submission is made. I have recorded that.
Or my submissions may be recorded, Your Lordship, that there is no prayer. So
Yes,
at this stage, when the joint receivers are there,
Yes,
Your
also,
Lordship,
although there is no specific prayer, but on the submission and considering the exigency, this court thinks fit that a special officer may be appointed. Dash is appointed. The learned special officer shall cause inspection upon notice to all the parties
and the joint receivers
and their learned and the joint receivers and their learned advocates, and submit a report by 25/6/2025. The copy of this application GA 12 of 2022 shall be served upon the learned special officer.
and Your Lordship, the remuneration be borne by the
Yes,
defendant
yes,
number
yes,
one.
definitely.
Defendant
No,
number-
remuneration is to be borne by the petitioner.
Yes, Your Lordship. Defendant number one
Yes,
is the
yes, yes, yes.
Yes, my lord.
Basing this on record, I have taken instructions from the client. And we are agreeable to the appointment of this guy.
No, this is for a limited purpose.
Yes, sir.
Only that inspection and report, nothing else.
Records the fact that I have taken instruction, I am submitting this on instructions, then.
I have not recorded your objection also, just heard.
Yes,
No, I have not stated
Millard,
that
he is
you
not
have
objecting. He
I'm
is
objecting
supporting
on
Millard.
that's placed in-
He is supporting Millard. It is the plaintiff who is objecting, Millard.
No, I'm not objecting. I'm
I've
saying
just
Your Lordship,
recorded.
prayer is not there.
Yes, yes, I have recorded that there is
Yes,
no prayer, but considering the
Yes,
exigence.
it's
Your lordship, please so kind as to permit us to file affidavits in support of.
Okay, let affidavits be filed in the meantime. Yes, 25th of June.
by 25th of June.
And GA 14, Your Lordship, the pleadings have been completed. So it
That
can
is
be taken up
340.
340.
Anyway, that is not so much urgent.
But one more line to be added, Millard. No further time to be granted, Millard.
Yes,
No further time to be granted for exchange of affidavits, Millard. It has been continuing since last 3 years.
yes, it can be granted subject to the payment of costs.
Yes,
What is the
that is
difficulty?
up to my lord. That is up to my lord.
তিনটে সময়। Yes, call the appellate side matters.
That matter, my lord.
Yeah, just a minute. Just a minute. Yes. No, but there are few short matters. Just wait for 10-15
Can it be taken on 30th or instead of 25th? Your Lordship, Mr. Mukherjee will not be there.
Who?
Mr. My advocate on record.
আচ্ছা ওটাকে তাহলে
25
25 তারিখ করে দিন তো।
Instead of 25th, maybe it be 30th.
30th is this thing. Okay, ওটাকে 30 তারিখ করে দিন।
I'm grateful, Your Lordship.
But intimate him.
Yes, I'll intimate him.
Anyway, you will take the copy of the order.
Yes, sir.
ওটাকে যেটা 25/6 করলাম তো ওটাকে 30/6 করে দিন।
I'm grateful.
Yes,
Side
original
except-
side, wait for 10-15 minutes.
My lord, appellate side matter, my lord.
Yes, appellate side, call the appellate side matters. Huh? দশ পনেরো মিনিট পরে আবার ব্যাক হবে অরিজিনাল।
My lord, it is that matter would kindly recall, my lord, that Devottor matter where.
Yes, where is the other side?
My lord, other side is there, my lord.
My lord, yes, the matter
But it was hard and the written notes of argument are already on record.
One thing, my lord, plaintiff opposite party number one in the meantime died. Otherwise substituted not.
Now, whether plaintiff opposite party number one has died, but all the other legal heirs are already on record.
So you take out an application. Anyway, let me record an order. Learned advocate for the petitioner
No.
and learned advocate for the opposite parties are present.
No, not recorded.
As this matter was heard at length on few dates, let this matter may be treated as parted matter. Let this matter appear on (13/6/2025).
And the interim order has
interim order granted earlier stands extended for a period of.
Let it be extended till the disposal. Otherwise,
period of 4 weeks after vacation or till the interim order granted earlier stands extended for a period of 4 weeks after vacation or till further orders, whichever is earlier. Take steps whatever you can in the meantime with necessary applications. Yes.
Milord, I am for the yes,
One day I've heard this matter. It cannot be a parted matter. Okay. If I would have heard the matter at length, it could have been a parted matter. Just one day I've heard this matter.
Yes, Milord.
So let it be released. You try before the regular bench. Yes, item number 2. It is not even recorded as a parted matter.
No.
Yes, item number 2. As this.
Kindly, Your Lordship, show the last order. 13/3/2025. Order number 5, last one, my lord, has not been complied with. That is that no copy of the reply has been given to me. Evening.
Learned advocates for the parties are present. As the matter was not heard at length,
আমার কপি দেবেন না
the matter is not treated as a parted matter. The matter stands released from the list and may be placed before the bench having determination. Same with regard to 2, item 2.
No, my lord.
3, item 3.
No, my lord. Item 3 was hard in part, my lord.
Let me see that. You are appearing item 3.
No.
Let me see.
ইচ্ছে করে দিচ্ছে
It was hard in part, my lord.
Yes, record an order. The matter, as the matter was heard and concluded and date was fixed for filing written notes of arguments and judgments, the matter may be fixed under the heading to be mentioned for filing written notes of arguments and judgments on 13/6/2025.
Yes.
So file written notes and judgments, whatever you can on that day, 13th of June. Huh? No, to be mentioned. Yes, fixed matter, call the fixed matter 3 p.m. matter.
So your lordship takes up the fixed matter. Your lordship had taken up item number 26 and asked me to wait for 2 minutes.
Item
26 and asked me to wait for 2 minutes. So I was here, Mr. Subhashish Sengupta appeared. That is why your lordship had asked me
What is the urgency?
Lordship then makes it not today, your lordship. The OL had been directed to appear and submit a report multiple times.
Who? Who?
The OL.
Yes.
Had been directed to submit a report multiple times. Your
Yes.
lordship. On the last occasion, lordship had passed an order asking the OL to, for the final time, to write a letter, which I had duly filed, your lordship. If your lordship takes a look at this.
Okay, then I'm keeping it after vacation.
Kindly keeps it after the vacation. Kindly directs the OL to be present physically. Otherwise, I am in a soup. I'm not being able to move ahead with the matter. It's a very old suit.
Yes, item 26. Okay, I'm just making it not today.
Kindly make it order to direct the OL to.
I'm making it not today. I shall pass necessary orders tomorrow.
Wait.
Fixed matter.
বলো এই চার্টের কপিটা দু তিনটে আদার সেটকে দিতে হবে My lord, time is precious.
Yes.
To assist your lordship, my lord, I made a chart of what was the plaint case, what is the deposition, and which is a relevant document.
Yes, you see the maintainability point of limitation and thereafter the merits under the specific relief. All three.
And all other issues, my lord. That's it. Lordship, give me a minute. Exactly. এই জাজমেন্ট কপি জাজমেন্ট Lordship, can you look at the plaint? Lordship, kindly take up the plaint.
Yes.
If I recall, it's paragraph number 32. At page, internal page 19, the my lord's list.
Yes.
Paragraph 32, my lord.
Page 13.
Page 19, my lord.
Page 19.
19. 19. প্যারাগ্রাফ গুলো দেখতে হবে দইবেন আর কোন মামলাই ছিল
That is a schedule of property.
না প্যারাগ্রাফ amended plain paragraph 32
288. Paragraph 32.
Yes, ma'am. দইবেনের কমার্শিয়াল কোর্টে ছিল কমার্শিয়াল কোর্টের নামটা যেন কি ছিল
Yes, the cause of action.
কমার্শিয়াল কোর্টের মামলাটা কি ছিল লসিম হ্যাঁ নামটা কি ছিল হিতকো মাহেশ্বরী রাইট হ্যাঁ yes Lordship, that the cause of action arose on 5/12/2008 when the defendant ultimately refused to comply with the terms of the memorandum of understanding dated
28 January 2005 and categorically denied to execute the deed of conveyance in favor of the plaintiff with respect to the suit property. So, cause of action as pleaded in the plaint is 5th of December 2008. Now, Lordship, can you look at the writ of summons or the first page of the আসলে আমাদের গুলো এত মানে বিচ্ছিরি ভাবে আছে না। The suit was filed on 28th of June 2014. Let's look at the beginning of the plaint. The suit was filed on 28th of June 2014.
Yes.
And I might recapitulate Lordship's manner that this is not the continuation of the city civil court suit. This is a fresh suit filed on 28th of June 20.
So pursuant to the leave granted, instead of filing the
same plaint,
they
filed a fresh suit. It's not a continuation of the city civil court plaint. Contrary to the order passed by.
Are they entitled to get relief under section 14 of the Limitation Act? Are they entitled to get any exclusion of time?
No, my lord, they cannot, because this is a fresh suit.
Yes.
From the cause title itself, this is a fresh suit. Cause of action on 5/12/2000, Lordship notes 2 dates only. 5/12/2008, 28 June 2014. 2 dates, Lordship, got it?
Yes. So this is cause of action.
And suit
34, para 34 is the suit filed. So the question is whether that is the question. The section 14 is applicable.
So cannot be applicable because this is not the continuation of the city civil code suit. This is a fresh suit. The number, the first page, Lordship looks at it. It's filed in a High Court format. The very first page.
Yes.
So 28th of June 2014, Lordship got it?
Yes.
Now, what is the well, previously the view was that limitation is a mixed question of law and fact. Now, I have shown they have not in this High Court suit, they have not. They are supposed to give explanation for the delay. No explanation has been given. Lordship, look.
You see, in suit there is hardly any scope to give explanation of delay. They have to show either you are filed within limitation or not filed, or you are entitled for exclusion or not.
Exclusion.
You are not entitled.
Exclusion.
Only is a question of entitlement, no question of any condonation.
Lordship. Is a primary, is the original proceeding. Section 5 doesn't like
giving any explanation. If there is any delay and they give satisfactory explanation also, the court is helpless.
Lordship. Now the law relating
to the
law relating to limitation has undergone a sea of change in the recent years, my lord. May I show two? Okay. Well, the first decision I'm citing is 2020 volume 7 Supreme Court cases 366. Divide to the them. কোনো আমার এখানে ওই মামলার জন্য ছিল, এই মামলায় আমার লেখা আছে দেখছি। আচ্ছা, আমার এই নোটের মধ্যে লেখা আছে কি? নোটের মধ্যে লেখা আছে কি? হ্যাঁ, লিমিটেশন। And Lordship, the relevant article is Article 54 at a Limitation Act, Limitation Act. Lordship, can you looks at Article 54 of the Limitation Act. Yes. Workout করা আছে কমার্শিয়াল মামলায় ওটা থেকে পড়ে দিই Lordship, Article 54 for specific performance of a contract 3 years, that date fixed for the performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. And their case in paragraph 32 is on 5th December 2008, the defendant refused to comply with the terms of the contract. So it's 3 years from 5/12/2008. But there is no evidence that cause of action arose on 5/12/2000. There was refusal. They could have recorded by a letter, by a contemporaneous letter that you have refused. This is refusal illegal. We don't accept it, and something like that. Nothing on paper. And Lordship will be surprised to see there is no questions are put in evidence also. Actually, the limitation started in 2005. So it's 3 years from the date of knowledge, and here which they plead is now the judgment I have given at 2007, 2020, volume 7, Supreme Court cases 366. Lordship comes to paragraph 7 first. On 15/12/2014, 7 SCC, yes, at paragraph 7 at page 373. Page 373, paragraph 7. Yes. Lordship got it? Well, on 15 December 2014, the plaintiffs filed special civil suit number 718 of 2014 before the principal civil judge, Surat, against the original purchaser, that is respondent number 1, and also implemented the subsequent purchaser, that is respondent number 2 and 3, as defendants. It was internally prayed the sale deed dated 2/7/2009 be cancelled and declared as being illegal, void, ineffective, not binding on them, on the ground that the sale consideration fees the collector had not been paid in entirety by the respondent number 1. 3 dates: 2014 suit filed, praying the sale deed of July 2, 2009 be cancelled and be declared illegal. That was the suit. Now, what does Supreme Court say? Lordship can take a paragraph 25. The Limitation Act 1963, paragraph 25 at page 380. 380. The Limitation Act 1963 prescribes a time limit for the institution of all suits, appeals, and applications. Section 2, subsection J, defines the expression period of limitation to mean the period of limitation prescribed in the schedule for suits, appeals, or applications. Section 3 lays down that every suit instituted after the period of limitation, after the prescribed period shall be dismissed, even though limitation may not have been set up as a defense. Even though I have not pleaded, I have not taken as a defense, but if it is not covered by the schedule, it shall be dismissed. Now, Lordship kindly sees 27, Lordship. Yes. Though dealing with 58 in Khatri Hotels, paragraph 27, Lordship. In Khatri Hotels Private Limited by the Union of India, this court held that the use of the word first between the words sue and accrued would mean that if a suit is based on multiple causes of action, the period of limitation will begin to run from the date when the right to sue first arises, accrues. That is, if there are successive violations of the right, it would not give rise to a fresh cause of action, and the suit will be liable to dismiss if it is beyond the period of limitation counted from the date when the right to sue first accrued. So here their case is 5th December 2008, so it should start running from 5th December 2008. If you take their case or plain case, now what is pending? 29.11. Paragraph 29.12 at page 384. Got it, 29.12. Here they have summarized, my lord, the principles. 29 from 29.1. They have summarized the principles. (29.11). Lordship got it? Lordship.
29.12.
11.
11.
I'm sorry, my lord, 21.2. I'm 1.
12.
On a reading of the plaint, it is clear that the cause of action arose on the non-payment of the bulk of the sale consideration, which event occurred in the year 2009. Here it arose in 2008. In my case, the plea taken by the plaintiff is to create an illusory cause of action so as to overcome the period of limitation. The plea raised is rejected as being meritless and devoid of any truth. Now 29.13. The conduct of the plaintiffs in not taking recourse to legal action for over 5.5 years from the execution of sale in 2009 for payment of the balance sale consideration also reflects the institutional present suit is an afterthought. The plaintiffs apparently filed the suit after the property was further sold by respondent 1 to respondent 2 and 3 to cast a doubt on the title of respondent 1 to the suit property. At the time resale, it was filed. Now, 29.27. Not necessary. 29.18. Lordship can take up page 385, para 29.18. Lordship got it? The delay of over 5.5 years after the alleged cause of action arose in 2009 clearly shows the suit was clearly barred by limitation as per Article 59 of the limitation 1960. It was 59 suit. The suit was instituted on 15/12/2014. In my case, 28th of June 2014. Even though the alleged cause of action arose in 2009, when the last check was delivered to the plaintiffs have failed to discharge the onus of proof the suit was filed within the period of limitation, the plaintiff is therefore liable to be rejected on Order 7, Rule 11D CPC. It was the Order 7 Rule 11 case, but I can always also take that in final hearing also, I can take that point. Lordship. And so here the plaint was rejected and suit was held to be barred by limitation on the basis of pleadings on the plaint. Now, Lordship, the next case I want to rely upon is 2020, Volume 16, Supreme Court Cases 601. 2020. Three the facts. 2020-16. If Lordship takes a paragraph 3 at page 604, which gives the facts of the case.
Paragraph 3.
Lordship. The facts of the case.
Yes.
Lordship. The facts leading to the present appeal, in a nutshell, are as under. That the original plaintiff and his brother Shiv Prasanna Singh jointly purchased the suit land in question in the year 1965. That the original plaintiff, who is the father of the appellant herein, original defendant, and his late brother Shiv Prasanna Singh, executed a registered deed of gift in favor of the appellant herein on 6th March 1981, gifting the suit land and put him in possession thereof. So, in 65, purchase, then a portion gifted in 81. That the appellant herein, original defendant, instituted one TA title suit, partition suit number 2003 of 2001 against his brothers and others for partition of the joint Hindu family properties. That the responding hearing, original plaintiff in the present suit, was also joined as defendant number 10 in the same suit. It appears that the summon, along with the copy of the plain opposite partition suit, was allegedly served on the plaintiff respondent hearing on December 2001. That Shiv Prasanna Singh died on 15 December 2002. That thereafter, the respondent hearing, original plaintiff alone filed the suit in question, title suit number 9 2003, against the appellant hearing, original defendant, in the court of Munsif Danapur, for a declaration that the deed of gift dated 6 March 1981 executed in favor of the appellant is showing sham transaction and no title and position with respect to the gifted property ever passed to the appellant, original defendant, hence the same is not binding on him. So, well, summarizing here for a second, three dates are relevant. They purchase the property, big chunk of property, 65. Then 1981, a portion is gifted to one of the appellants, gifted to appellant. Now, then appellant filed a partition suit for partition of the property and served the writ of summons on the plaintiff. Then the plaintiff filed the present suit TS 19/2003, saying that the deed of gift of 6 March 1981 was a sham transaction. Now, Lordship takes up paragraph 7. Actually, right. Lordship takes up the paragraph. The submissions are recorded in paragraph 4. If your Lordship takes up, no. Lordship, take up the submission, it is further submitted, recording submission, which will be their submission also.
Paragraph 7.
Paragraph 4.2 at page 605. It is submitted that in the present case as
4.2.
Lordship.
It is further submitted.
Further submitted by the learned counsel appearing on behalf of the appellant, original defendant, the High Court as well as the trial court ought to have appreciated the fact that by mere clever drafting, the plaintiff cannot bring the suit within the period of limitation. If otherwise the same is barred by the law of limitation. It is submitted that in the present case, as such, the original plaintiff deliberately did not specifically pray to set aside the registered gift deed dated 1981. It is submitted if the plaintiff would have asked for such a relief, in that case, the plaintiff was aware the suit would be dismissed as a threshold being barred by law of limitation. It is submitted that therefore, deliberately, the plaintiff specifically did not ask for the relief of quashing and setting aside registered gift deed. In a tricky manner, it was prayed. Even then, what is the finding? Lordship, kindly come to paragraph 5.1 at page 607. Yes. Which submission I am sure the plaintiff will take here also. It is vehemently submitted by the learned counsel appearing on behalf of the original plaintiff that the question of limitation is a mixed question of law and facts, and for which the evidence is required to be led by the parties, and therefore both the High Court as well as learned trial court rightly refused to reject the plaint at the threshold in exercise of powers under Order 7, Rule 11 CPC.
This is not an Order 7
Rule
rule.
11, right.
This is on the argument stage after
argument stage.
So that
Evidence has already been laid, my lord. So
we have to consider the evidence as a whole, and then
Lordship.
that plea is not available now.
Yes, it's no longer available. Now, Lordship, come to paragraph 7. Though it's basically an Order 7, Rule 11, but the principles, ratio and limitation, I want to lay down, my lord.
No, what can be argued in Order 7, Rule 11, and what can be submitted in argument?
My lord, what I can argue in Order 7, Rule 11, I can also argue at the final stage.
Yes,
but what I can argue at final stage, I cannot argue in the Order 7, Rule 11.
That is, Order 7 scope is limited.
Limited, Lordship is absolutely. This is we are after evidence. Yeah. Right.
So we have to show the evidence.
If your Lordship kindly takes up paragraph 7, it is placitum B at page 611. Placitum B on the left. Lordship kindly see the deed of gift. Lordship got it?
Yes, yes.
The deed of gift was registered gift deed. The execution of the gift deed is not disputed by the plaintiff. It is a case of the plaintiff that the gift deed was a showy deed of gift, and therefore same is not binding on him. However, it is required noted that for approximately 22 years, neither the plaintiff nor his brother claimed at any point of time that the gift deed was a showy deed or gift. One of the executants of the gift deed, brother of the plaintiff during his lifetime, never claimed that the gift was a showy gift or gift. It was the appellant herein, original defendant, who filed the suit in 2001 for partition, and the said suit was filed against his brother, to which the plaintiff was joined resolution number 10. He appears the summon of suit filed by the defendant. It appears that the partition was some defendant herein. Despite the same, he instituted the present suit in the year 2003. Even from the averments in the plaint, it appears that during these 22 years, that is period 81 to 2001, 2003, the suit property was mortgaged by the appellant herein, original defendant, the mortgage is executed by defendant. Therefore, considering the averments in the plaint and the bundle of facts stated in the plaint, we are of the opinion that by clear drafting, the plaintiff has tried to bring the suit within the period of limitation, which otherwise is barred by law of limitation. Therefore, considering the decisions of this court in T. Aravindandam and others as stated above, and as the suit is clearly barred by law of limitation, the plaintiff declared defective so and so. Paragraph 9. So far as the application on the original plaintiff and even observation made in the court as a high court that question with respect to limitation and mixed question law and facts which can decide only after parties led evidence is concerned, as observed and held by this court in Shamlal so and so as well as so and so, considering the averments in the plaint, if it is found that suit is clearly barred by law of limitation, the same can be rejected in excess power order 7 rule 11. Well, what can be done order 7 rule 11 can obviously be done at the final hearing after evidence has been led. So the principle of law is laid down paragraph 9. Considering the averments in the plaint, if it is found suit is clearly barred by limitation, then the suit has to be dismissed. It's very clear, my lord. And today you have crossed the stage of mixed question of law and facts, which is not a order 7 rule 11 application. So, my lord, the suit is, as we say, hopelessly barred by the law of limitation, and therefore, at the threshold, it should be dismissed. Apart from the other lacuna, other defenses, my lord.
Now, this is all on the point of limitation.
Yeah, this is so far on the point of
limitation. Now you will come to the merits of the case.
Lordship. If logically takes up the chart, madam. I've tried to cut short the time of the court, my lord, and also my hearing time. So at a glance, it is available, my lord. Position.
Yes.
Documents. Lordship, first take the plaint. Actually, there was a previously agreement that was cancelled. My lord, no point today, those are not relevant today. So I'll start from paragraph 17, where from where the agreement starts. Paragraph 17, logically see that on mutual understanding between the plaintiff and Jyoti Laser Point and the defendant. So there are tripartite agreement. There are three parties. Logical find plaintiff, Jyoti Laser Point, defendant. Plaintiff is Jyoti Avashan, my lord. It should not be confused. It's a little similar in name. Plaintiff is Jyoti Avashan, and the other party is Jyoti Laser Point and defendant. Three parties. It was decided that the oral agreement between the plaintiff and Jyoti Laser Point and defendant with respect to the sale of the suit property must be reduced into writing, and as such, in pursuance to the oral agreement for sale of a memo of understanding duly stamped had been executed on 28th day of January 2005 by and between the defendant as vendor and the plaintiff and Messrs. Jyoti Laser Point as purchasers, and therein the memo of understanding the entire payment of 15 lakhs till the date paid by the plaintiff and Mrs. Jyoti Laser Point to the defendant was endorsed and acknowledged by the defendant by a receipt forming part of the memo understanding. The original kept in the records of the defendant with a true copy without stamp of the same with the plaintiff. Now, Lordship, come to the chart. This is at a deposition copy document. No, compilation নেই। ওদেরকে দিতে হবে। বাহ। ডিপোজিশন গুলো দেখি তো। হ্যাঁ, ডিপোজিশন
ফাইলে হবে
সব কটা ডিপোজিশনই দরকার নেই, থাক থাক রাখুন রাখুন। My lord, all the depositions have made a compilation. My lord, may I hand over? এটা রাখুন, ওটা রেখে দিন, ছিঁড়ে যাবে ওগুলো। হ্যাঁ, দিতে হবে দিতে হবে
দিচ্ছি
দিতে হবে। My lord, plenty ought to have done it.
Anyway,
Anyway, my lord,
you have
now
done
the, my lord,
you have done him a favor.
yes, no, no, my lord, they are good friends, my lord. So,
Getting all the documents, that's why.
দেওয়া উচিত হয়নি না?
দেওয়া উচিত হয়।
Lordship, may I start? Now, deposition, question 146. In this, possibly page 20, Lordship, can you have a look? Page 20. I have given index also, my lord, at the top.
Yes.
Page 20, Lordship. The question 146.
Yes.
That was the chief, examination is chief of the PW. I am handing over to you a document. Kindly tell my lord as to what this document is about. This is a contract which has been signed by Jyoti Abashon, Jyoti Laser Point, Dibbojyoti Rai, SBS Maharaj Hospital Trust, and second page 3 persons have signed. Apart from them, there are 2 witnesses, namely C.A. Jonathan, G.K. Agarwal, and on the third page of on behalf of Marwari Trust, T.R. Jalan has signed. This is a receipt for a sum rupees 15 lakhs. Can you look at the document, say as to who has signed the document? T.R. Jalan, SBS Marwari Hospital Trust. Encircle the signature reading. This is exhibit Q. This is exhibit Q. This is, they show this is document. This is, now Lordship can look at the judge's brief of document.
এক্সিবিট কিউ
জাজের ব্রিফটা ঘাঁটতে সুবিধা হবে না, দাঁড়ান জাজের ব্রিফটা দিন। হ্যাঁ, প্লেন্টি, হ্যাঁ হ্যাঁ হ্যাঁ, প্লেন্টিভস ডকুমেন্ট দেখুন, হ্যাঁ সুবিধা হবে।
সিরিয়াল নাম্বার 2,
It is page 2.
These are the documents which are exhibited.
Yes.
অরিজিনাল আছে না, এক্সিবিট কিউটা দেখে
Yes, page 2.
Page 2.
MOU.
MOU, Lordship. এটা হতে পারে না।
লিস্ট অফ এক্সিবিট,
লিস্ট অফ এক্সিবিট কিউ,
ওটা না
এইটা, হ্যাঁ হ্যাঁ, এটা দেখি এটা দেখিয়ে দিন। ট্রাস্ট, হ্যাঁ ঠিক আছে ঠিক আছে, হ্যাঁ হ্যাঁ হ্যাঁ, আছে আছে আচ্ছা আচ্ছা, ঠিকই আছে, ঠিক রেখে দিন, এটা অরিজিনাল গুলো থাক। হ্যাঁ, লসিক দরকার নেই, but it is easier to show from the document. Lordship can mark also, otherwise original document shabd hoye jaye. Memorandum of understanding. SBS Marwari Hospital Trust, Trust having its present office at 11B Raja Rammohan Sarani, Kolkata 7,09,000 West Bengal, here referred as vendor. Having agreed to sell their property situated at and being premises number 1 and 1/1, formerly 9 and subsequently 5, Decker Lane, holding number so and so in the town of Kolkata, to Messrs. Jyoti Abasan, 6D, Ramnath Mojumdar Street, Kolkata 9, and Messrs. Jyoti Leisure Point, 63/2B, Surjo Sen Street, Kolkata 7,09,000 as the purchasers. So there were two purchasers. Lashuk, got it? There are two purchasers, right? Details of the property I am not taking, my lord. This is a 10 katha land property. Background: the vendor has been and is the sole owner of the property. Trustees of the vendor meeting on author passed resolution authorizing the trustees to negotiate, settle, and conclude this sale of the above property. Price: the sale price will be 35 lakhs only. Now, Lordship turns the page. Payment: cross account pay check drawn on Kolkata Bank for rupees 15 lakhs is to be paid in advance by the purchaser as earnest money to the vendor, and this pay order shall be deposited to the bank for clearance. Above earnest money will be free from any interest. Now, logically mark this paragraph. Balance payment is to be paid by the purchasers to the vendor at the time of execution, registration of conveyance within 28th February 2008.
2005.
2005. I'm sorry. I'm so sorry. So the balance is to be paid and documents to be registered within 20th February 2005. In case the purchasers fail to pay the balance amount as above within 20th February 2005, the earnest money 50 lakhs will stand forfeited. So time was the essence. It was made clear two clauses. One is to pay the time of execution registration. Second clause that clarifies that and makes it clear that they have to make payment by 28th of February 2005. And 4.3 says, if they fail to pay, then the earnest money will be forfeited. Very clear, my lord. Not much of legal language. It's a very clear commercial language. No question of dual interpretation. So, next 4.4 is further emphasizes that timely payment is the essence of this deal. The purchasers have seen and verified the original title deed of the property and are fully satisfied with the same. The purchaser shall meet all liabilities on account of rates, taxes, imposition, and outgoings, including that of Kolkata Municipal Corporation, respect the property up to the date of execution of deed of conveyance, and each party should keep other party safe, harmless, indemnified, usual. Stamp duty, registration fee, agreement, all other costs to be borne by the purchasers, and they'll pay the brokerage to some Jajudia. So, the balance money is to be paid at the time of execution registration, which is to be done by 28th February 2005. And the balance payment is to be made within 20th February 2005. And in case they fail to pay within 28th February 2005, the earnest money will be forfeited, and timely payment is the essence of this deal. Very clear, my lord. Now, Lordship, look at the cross-examination of PW from question 169, that comparison I just now handed over, depositions. like anyone. This is to Mr. Utpal Bose, Senior Advocate in Cross Examination, the PW.
That is
Page
20.
23.
23.
Because, my lord, that original depositions, they are not paginated. To every time I have to find it, your lordship, and when writing judgment also, lordship will find difficulty in finding that page. So, my lord, this compilation is very helpful
So
to both of us.
cross-examination by Mr. Bose.
Bose, yes, my lord. Kindly come to question 169. Lordship got it?
Yes.
169. Kindly come to prayer A of the plaint. Do I take it that you have asked for a degree of specific performance of the memorandum of understanding dated 20th February 2005? Answer is yes. The document I just now showed as PD2 at page 2 of the judge's brief of documents. Now, I take it the exhibit Q is the memorandum of understanding dated 20th January 2005 that you're talking about? Yes. Is this document duly stamped in accordance with law? No. But this is also one of the issues in maintainability. A document which is not
exhibited with objection.
With objection, yes, madam, of course, which has not been duly stamped cannot be even looked into. If
then how is it exhibited?
Subject to objection.
So how it can be, even if
it cannot be looked into, then, my lord. That
is not said. Why objection?
Lordship. So it has not an exhibit.
It is inadmissible. It cannot be given consent to or objected to. Neither. Neither by consent it can be exhibited. Neither does it change the legal position. If it
Speaking the language of Supreme Court, my lord, I cannot add more. Section 35 Stamp Act says that even by consent, it cannot, by acquiescence, it cannot be taken into it. That is the language Supreme Court. Lordship has just repeated, my lord. It makes our job easier. Lordship, law is very much known to your lordship, my lord. So, is this document duly stamped in accordance with law? Answer is no. Is this document registered in accordance with law? I have no knowledge about legalities, but it has been signed by TR Trustee SVS Marui Hospital Trust. Neither here nor there. It is neither stamped nor registered. I am putting it to you that in the absence of registration and in the absence of being stamped, this document cannot be looked into and is liable to be impounded and inadmissible in evidence. His suggestion, he says disagree. But I have
anyway, after all, it is a curable defect.
Yes. Yes. If they want, even now they can impound it.
It is the court's duty to impound it.
Impound it. Lordship. Option
Obviously, their suit.
But option is with them. They can proceed as it is, or if they want, they can ask for impounding. But court cannot, unless impounded, court cannot look into that. And if the document on which the specific performance relied upon cannot be looked into, then there can be specific performance in the air. On what basis they are asking? Lordship. May I place this part of the cross examination? Now, question 177. Kindly come to clauses 4.2 and 4.3, just now I have placed, which says the balance sum is to be paid within 20th February 2005, failing which earnest money will stand forfeited. Did you pay the balance sum within 20th February 2005? Specific question, my lord. We are supposed to make the payment of 20th February, but simultaneously with execution registration. My lord, the agreement doesn't say so. Lord, you can look at the agreement. Just a second. Lord, you can look at the agreement.
Page 3.
Page 3. Lord.
What is it? What is it?
4.2. The balance payment is to be paid by the purchasers to the vendor at the time of execution registration. Then 4.3. In case the purchaser fail to pay the balance amount as above within 20th February 2005, the earnest money of 15 lakhs will stand forfeited. So, to wait till execution and registration is a ploy, is a plea. The agreement says you have to pay it within that date or it stands forfeited. And that was the specific question. That kindly look at clauses 4.2 and 4.3.
Yes.
Which say the balance sum is to be paid within 20th February 2005, failing which the earnest money will stand forfeited. Did you pay the balance sum within 20th February? We was supposed to make the payment of 28th February, but simultaneous to execution registration. The agreement doesn't say so.
So at present, what should be done? It's better the court should invoke the power and impound this document. Yes, what do you say?
Shall address this point.
So at that point of time, it may be very too late. You take instructions on the next day.
Or Lordship can record that they let them take instructions and state the court on the next day whether they want to impound the document. That can be recorded, madam.
So actually, the duty is cast upon the court.
Of course, madam. Lordship can send it, madam.
They have not even taken this issue of stamping in the written statement.
Anyway, but what is there in the record? You see, in the evidence, in the record, is MOU other than agreement for sale? Why, with regard to sale of immovable property, it is.
Yes.
Agreement, understanding with regard to sale. If you want to enforce it, you have to treat it as an agreement for sale. If you want to treat it as an agreement for sale, the court has no other option but to impound it.
Lordship, Section 35 doesn't give any option.
Anyway, you submit, they let them come with instructions after vacation. And even if they don't come with instructions, the court
can
has the power.
I think, my lord, Lordship can record that, my lord. This is to be impounded and let them take instructions whether on this issue. That should be recorded in the order, my lord. Otherwise,
This is a final hearing stage, my lord. Kindly do not record, my lord.
The court, even at the appellate stage, can impound a document.
My lord, let us address lordship and thereafter lordship.
You see, you may take your chance, but it may be very too late.
My lord, kindly keeps it after the vacation. We shall address your lordship as to whether it is required at this stage or not.
Learned counsel for the defendant submits with regard to the facts of the case, but could not conclude the arguments in the consideration of the case. A question has come for consideration with regard to impounding of the document being namely memorandum of understanding, which is marked exhibit Q.
Subject to objection, my lord.
Subject to objection. Learned advocate for the plaintiff prays for time to take necessary instructions on this matter to submit. Thus, time is granted to the plaintiff. Let this matter appear for further arguments on, yes, when?
My lord, convenience, my lord. We are at lordship's convenience, my lord.
Okay.
Court convenience is first.
Yes, yes. 18 জুন দেখুন তো কিছু আছে কিনা 3টের সময় Any other than Friday, any day.
I leave it up to your lordship, my lord. It's our duty to be here whenever lordship
So
fixes.
that is why I am keeping it at 3 p.m.
Yes, my lord.
18 তারিখে আছে 3টের সময় কিছু 18 তারিখে
19
আর 2 p.m. আছে কিছু 18 তারিখে আচ্ছা 18 তারিখ 19 তারিখে 3 p.m. আচ্ছা ঠিক আছে 18/6/2025 at 2 p.m.
Very well.
Necessary instructions may be obtained in the meantime.
My lord, let it be treated as part heard. Lordship has heard substantial for 3 days. Let it be treated as part heard,
This
my lord.
should be treated as a part heard. Huh? Huh? Can you take any matter, passed over matter, both sides present? Yes, any passed over matters, both sides present? जागे ये take আচ্ছা ये কালকে ফর অর্ডারসে যেটা আছে ওই সিএস আর জিএ যেটা ওটাতে একটা ফর অর্ডারস আছে কালকে ওটাতে কি রিটেন নোটস অফ আর্গুমেন্টস যেটা দেওয়ার কথা ছিল সেগুলো কি দিয়েছে ওটা একটু পাঠিয়ে দিন তো তাহলে আমার ঘরে
Deeply obliged, my
যদি পাঠিয়ে থাকে তাহলে দুটো পাঠিয়ে দেবেন আমার চেম্বারে
Good, Babu. Last year.